public hearing on House Bill 1292, and I call Representative Luno.
Thank you very much, Madam Chair and members of the committee. My name is David Luno. I represent the people who live in Hopkinton and Bow, and as I always like to say, as well as our statewide responsibilities, people that live in communities all across the Granite State. So what I'm here to present to you this morning is House Bill 1292, which is relative to a very, very minor change to the state retiree health insurance plan. And this was brought to my attention about a year ago. It was after the bill filing period by a constituent who is a recent state retiree state employee, and said that he was hoping to be able to keep their children on their plan, but their children were, I think, 24, 25 years old, and they were out of college now, and the current law with respect to eligibility of children between the ages of 19 and 25 requires children to be full-time students. So not being able to put a bill in last year, we did get a little bit of research help to take a look at it. What is the Affordable Care? What does federal law require? And federal law actually requires eliminating the limitation on children between the age of 19 and 25. Most plans can no longer require those children to be full-time students. But those changes through the Affordable Care Act at the federal level don't apply to the state retiree plan. And I don't remember all the details why the state retiree plan does not need to comply with that provision of the federal law. But all this bill does on lines 3 and 4 are just removing the limitation of full-time students. So any fully dependent minor children between the ages of 19 and 25 could be carried on the family plan for a retired state employee. And I do have some remarks actually from our constituent with respect to their situation and what prompted the request. And if you don't mind, Madam Chair, if I could just read it into the record, I can leave you with a copy, or I can
Just
summarize.
leave us with please summarize it and leave us with a copy,
No.
and we'll read it.
Fantastic. So our constituents both turned 60 years old in March of 2023. They served the state as state employees for more than 56 years of service. Their children are both recent graduates of the University of New Hampshire, and they're early in their careers. And they're wishing to be able to keep them on their state retiree health insurance policy until they turn 26. And it's important to know, and I think the fiscal note also states this, that the premiums on these policies are fully paid by the retiree. They're not paid for by the state. That's one big point on this. Second big point on it is we're bringing young kids, young people into the plan, which generally have a lower cost on them than many others. So we're hoping that this committee would look favorably on House Bill 1292 and recommend it ought to pass. So thank you very much. I'm happy to take any questions.
Representative Blackus.
Thank you. This is actually for the chair, and that is, I don't see Mr. Carlin here. Do you know if anyone's here from the retirement system? Because I have a question for them.
This does not involve the retirement system.
Oh,
The Department of Administrative Services, which is ready to testify but hasn't given me a pink card yet, administers this program.
I'll wait till
Mr.
she's
Carlin
available.
is not involved.
I understand. I'll wait till she's.
Okay, Representative Mangiaputi.
Thank you, Madam Chair. Thank you, Representative Luno, for taking my question. So these youngsters are currently on the retirees health plan, correct? And they are asking to retain them because they are not students. They've graduated from student.
Right. So this was, as of a year ago. So I don't believe they're still on the plan because they'd already graduated from the University of New Hampshire. Um, but I don't think our constituents in this case are necessarily the only constituents in the state that may have a similar situation where either they would want to bring children onto a family plan as opposed to just paying out of pocket for just the two-person plan. They'd be paying out of pocket for the family plan. And I think it's certainly a nice benefit with really no cost to the state to be able to help our retirees who have committed significant service to all of our needs.
Right, thank you. Other questions? Thank you very much, Representative Lunel.
Thank you
and
very
good luck
much.
in education. Thank you. Okay, and this is, thank you for the file. Joyce Pittman from Administrative Services.
Good morning, Madam Chair. So again, Joyce Pittman, I am the Director of Risk and Benefits with the Department of Administrative Services, and we run the Retiree Health Benefit Program. I marked support. What I'm really here is to answer your questions. I assumed you'd have some from a retiree health plan perspective. As far as the language in the bill goes, we don't have any concerns with this for a couple reasons. The biggest one is that currently today, in order for dependents to be covered under the retiree health benefit program, the retiree is responsible for 100% of the cost of that plan. So our first concern is how is it being paid for? And it is being paid for by the retiree. This is typically a low-cost population to serve. They're typically younger. They typically don't have a high cost demand on the healthcare system. But I think I heard a question being asked as to why the federal government, why we're exempt from that. This is a retiree health benefit program, and the Affordable Care Act refers to active employee health benefit plans. So the retiree health program is outside of the Affordable Care Act, also referred to as the ACA. So we are not required to cover dependents. However, although indeterminable of how many people will actually utilize the system, the retiree is paying the full cost of that coverage. So we have no reason to oppose this bill. And it, honestly, from an administration standpoint, some of these, I'll say, dependents go to school after high school to college, and then so they are, according to the bill as it is the law today, they're staying on their parents' health benefit plan until they're out of school. They're no longer full-time students. So by removing that full-time student requirement, it's irrelevant if they go to college or not. Once they're over the age of 19, they remain on the plan until through age 25, which does also align with the Affordable Care Act. So it just allows the student to stay on longer. So to some, the students have been on beyond the age of 19 because they had post-secondary education, and some didn't, and they would remain on the plan. I'm happy to answer any questions.
Thank you, Representative Groda.
So I just want to be sure that if we were to pass this bill and turns into statute, it would not have a cost to the people of New Hampshire. It would be strictly a policy, health policies that are paid by the retirees, correct?
The retiree would be responsible for the full cost, what we call the working rate, which is the full cost of the plan. So correct. That would be what I can't guarantee is that if you look on a member by member basis, remember it's a larger risk pool, right? So their working rate or what they pay, it's just under $1,000 a month per. The way the premium structure is you pay for one dependent. So if you have 3 children that are on the plan, you pay for one. And it's roughly about $1,000 a month, just under. I think it's $980 $83 per month. So whether or not that exceeds that, I'm not sure, but it would be applied to our regular calculation in the future.
Follow-up?
So are you saying that if you have 3 children, you pay for 1 and the other 2 are covered?
Yep.
Okay,
That's true today.
That's,
Right, okay.
that's typical of family plans.
It is
You get
exactly.
any number of children included.
That's correct.
Representative Lekas.
Thank you. So related, I don't remember if this plan, the state's self-insuring or it's through something else, but my question is, I mean, if it's self-insuring and somebody has 3 children, it is going to cost presumably the plan more for the other 2. But if it's part of some deal where you move to a family plan, then maybe the other 2 aren't going to cost more. So can you answer which it is? Basically, if there's more than 1 child, is it really going to cost the people in New Hampshire more money?
According to our actuaries, no. They do an actuarial calculation to figure out. I think your question is if it's the $983 for 1 individual or 3 or 4 or 5, does it impact the plan? Is that, or the taxpayers?
Correct.
The way the math works out, the answer is no. It comes out of the working rate. So in a future rate, we would take whatever that cost was, and it could potentially inflate the cost that retirees pay in the future. But I just want to remind people that this is a very small population and they're typically very healthy. So the chances of this doing anything to the cost of the retiree health benefit plan is really, it's indeterminable, but it's minimal, if anything.
Okay, thank you.
Yes, Representative Mangiapudi.
Thank you, Madam Chair. Thank you for taking my question. So this is youngsters that are just getting off or getting on their own 2 feet, and anytime they can transition out of their parents' plan, and would this impact dual enrollment or,
Whether or not it impacts dual enrollment, it depends on the health benefit plan, what the other plans are. Typically, when you stay on our health benefit program, it's primary. If there is another plan, they could look at the coordination of benefits specific to that plan. And as far as them being youngsters, so we're talking really when they graduate from high school up through age 25. So I'll let you decide whether or not they should be on their own. It's every parent's, family decision. But yes, it's a way of helping them transition into when they transition off of their parents, and it allows it to happen after they're age 25, if they have an employer plan available to them or something like that. It does put it in alignment with the Affordable Care Act, which is exactly what our active employee population has today.
thank you.
Other questions? All right, thank you very much. Is there anyone else who wishes to testify on House Bill 1292? Don't see anybody. In that case, I'm going to close the public hearing. Okay. All right. Since we have a few minutes, we will go into executive session, and Representative Grota has a motion.
yes, I move auto pass on House Bill 1292.
Is there a second? Second by Representative Gould. Do you wish to speak to your motion?
Thank you, Madam Chair. This bill offers the retirees the same benefits as someone on the ACA, and since the retiree is responsible 100% for the fees, I think that this is a good benefit for New Hampshire retirees who have families.
Representative Gould?
No further comment. Jackie said it all.
Okay. Representative Mangiapudi?
Thank you, Madam Chair. I think this gives a good opportunity for a young workforce to stay in the state. And, we are facing that entry level. So this will give their youngsters a peace of mind to have the medical benefit and then explore opportunities in New Hampshire.
you.
I think it's a great benefit. Thank you.
Anyone else? Comments, questions? Yeah, I'd like to say that increasing the size of the pool in this health plan with younger, healthier people than your average retiree is not generally felt to be a problem. Okay, 2, 8, 10, 11, we have a quorum. Yes, we have 11. That is a quorum, so we can take a vote. Any further comments? All right, those in favor? The clerk can call the roll. That's it. Forgive me.
Representative Lakis,
Yes.
Representative Dolan. Clerk votes yes. Representative Boyd,
Yes.
Representative Grota,
Yes.
Representative Schmidt,
Yes.
Representative Schuett,
Yes.
Representative Gould,
Yes.
Representative Smith,
Yes.
Representative Manjaputi.
Yes.
11 yea, 0 nay. Oh, and the chair. I'm sorry.
Yes,
I
It's all right.
My
I-
apologies.
I don't mind being overlooked.
Just getting over an illness. I apologize.
All right, so the motion passes 12-0. Is there any objection to consent? All right, seeing none, we'll put it on consent. Representative Grota, I'd appreciate a committee report at your very earliest convenience. All right. And we are, in fact, off until 10:30. We're going to be so coffeeed up today.
No, I got the wrong.
All right, today is the 30th.
Already had it? Yes. The very fact that you saw me pointing at you means it works.
It is 10:30 and I'm opening the hearing on House Bill 1435 and I call the sponsor, Representative Comtois.
Thank you, Madam Chair. Thank you, members of the committee. For the record, my name is Representative Barbara Comtois from Belknap 7. So this bill was brought forward due to a constituent letting me know that under current law, that in a divorce decree, if one spouse has a retirement system with the state of New Hampshire, and in that decree, they get a portion of that retirement system, no problems. However, when talking with this constituent, she was nearing Social Security age and was collecting what was in the divorce decree because the spouse had retired, a monthly stipend, I guess is what I'll call it. And so based on the amount she filed for Social Security, was retiring, and lo and behold, the former spouse says, you know what? Yeah, I'm going to go back to work, so now you no longer get that stipend. And under New Hampshire law, if somebody goes back to work, even if the spouse is already collecting the funds and relying on that as part of their cost of living, it goes away. Because apparently in the system, when someone goes back to work, their retirement benefits stop and they keep adding to the system. This has created a hardship, and in speaking with this person, they had also let me know that the person that they dealt with in regards to this had told her that she had other people calling up crying because they would lose their houses over this. Now, I'm not asking for people that are due the money that haven't started collecting to get the money. But if the spouse retires and then decides to go back to work, and in this case, we believe it was retaliation based on her comments. I don't know if that's true or not. I'm just relaying the story. Force this person back to work full-time. They were already working, but then also put them over the limit to make ends meet. So now that their Social Security is now taxed. So it was kind of like a double whammy because they collected early so that they couldn't, there's a certain age where you can only make so much money under the Social Security system. And so I brought this forward. I spoke with OLS. He said the commissioner said that this was a rare occasion that this happens, according to OLS, when they did the research, or legislative research, I should say. So I put in a simple line that says that if you've already started collecting because your spouse had retired, the payments don't cease to the other spouse if it's in the divorce decree. That's it. It's not saying everyone gets to start collecting or anything like that. It's only if it's already started that it can't stop. Because if it's hurting one person, it's hurting others, as we know how things go. But people don't know where to go and how to come forward. I just happened to be in a place where someone told me about this, and I felt that this really needed to be addressed, and I'm open for questions.
Thank you. Representative Smith.
If a spouse goes back to work, can you hear? I'm not sure this is
No.
close enough. I'm sorry.
It's okay.
You just turned it off.
High tech, I can't do it. No. Okay, if a spouse goes back to work, then he's or she is going to earn more money. That will increase the retirement for that person. Will it also increase the retirement for the spouse?
Thank you for the question, Representative. No, it's a set amount and a decrease, so that amount does not increase.
Okay, so the person receiving it originally will get only that amount. Okay,
Correct.
thank you. Thank you.
Okay, it also depends on the former spouse retiring a second time, which may be delayed. Okay, anyone else? Questions? Representative Schuett.
Thank you, Madam Chair. Hold this a little closer. Would it not be true that a person in such a circumstance would be eligible to go to court to pursue having support from their former spouse?
Thank you for the question. I did ask that question, but it's costly. And so it's a hardship for them to come up with those funds.
But they could, yes. Representative Baroda?
I'm under the impression that if you have to go to court and you don't have the funds, the court can provide a service for you. Is that not true?
Thank you for the question. I'm really not familiar with all of this. It's, however, the amount of time and then the time out of work, because they did have to go back to work, and wasn't, they didn't seem to think that it was the right thing to do, and they just decided that they would cut their losses at this time.
That the requirement for representation is for criminal actions. If you're suing in family court, you're not entitled.
Thank you for that clarification, because they did say it was going to be quite costly for them.
Okay, anyone else? Representative Mangiaputi?
Thank you, Madam Chair. Thank you for taking my question. This is very similar to child or alimony kind of thing. So you go back to the court or go back to the settlement if there is a change in life status, isn't it? So that would warrant, if there is a change in the life status, you would go back to change it.
Well, thank you for the question and looking at this. But this here, in this particular case that I'm aware of, it was kind of an I gotcha moment. It was they said, you know what, we're going to go back to work even though they were at retirement age and collecting retirement because they wanted to harm this person.
All right. Other questions? Thank you very much.
Thank you, Madam Chair. Thank you, members of the committee.
Mr. Carlin, let's get the facts out and then hear from Representative Pearson.
Thank you, Madam Chair. For the record, Marty Carlin, representing the New Hampshire Retirement System. The NHRS has not currently taken a position on this bill, although we do have some legal concerns with existing statute and the Internal Revenue Code regarding the application of the bill. Historically, as under current law, NHRS permits shared payment qualified domestic relations orders, referred to as quadros. This is a divorce decree or settlement adjudicated in court, and we apply that court order to any distribution of retirement benefits or other assets. As we don't, we just qualify it, but the courts make those decisions on who gets what, and so those can be a flat amount of a pension. They could be a percentage of a total pension. There's different permutations on that. But essentially, what the law allows that to happen is for that member's benefit, to a portion of it to be paid to someone else because of a divorce decree or divorce settlement. However, that doesn't make the quadro recipient a member. So our concern under current law is if the member, they're deriving a benefit as a portion of a retired member's benefit, and if the retired member isn't is no longer retired, there's no benefit to receive a portion of. You know, we would be essentially having to pay a benefit to a non-member, which is not allowed. It's, you know, under various statutes.
And the Constitution.
Yeah.
All right, that's a very interesting position. Representative Mangiapudi and then Representative Gould.
Thank you, Madam Chair. It was very, you explained it very clearly, interesting perspective, but how would this impact your whole New Hampshire retirement system by tweaking this, a non-member getting the benefit, access to the benefit?
It's you know, there is both in the Internal Revenue Code and in statute and in the Constitution, there's a clause, you know, for the exclusive benefit of members and beneficiaries. So providing any relief to a non-member would, arguably someone could say that's not it violates the exclusive purpose rule because it's not a member. I mean, the dollar amount, certainly with the size of the benefits we pay, isn't the issue. It's the question of opening the door to taking trust fund assets, which are, you know, member and employer contributions and investment income, and dispersing that to someone was not a plan member, you know, for a benefit. I mean, it's different if a member retires and can leave a survivorship option to a beneficiary. There's a whole legal pathway for that, and certainly non-members get money from us. But this is an issue that may be more the purview of civil court to this in this unfortunate situation that this person is facing.
Yeah. Representative Gould.
Thank you, Madam Chair, and thank you for taking my question. My question is, if the current statute and procedure is a retired employee and their beneficiaries, wouldn't a former wife that a court has declared entitled to a portion of it fit under a beneficiary category?
Well, if you can be nominated as a beneficiary, you know, for an active member if there's a death benefit payable to whoever the nominated beneficiary or
Okay.
beneficiaries are, you know, but in this case, it's a beneficiary for a pension that no longer exists because the person was restored to service. So there's no base benefit from which to draw a portion of.
Okay, and follow up.
Follow
Madam
up.
Chair. So in the event the court has ordered a flat fee, you don't have to calculate anything. Can you tell us how many circumstances you currently have where you're paying these ex-spouses based on court orders?
We have approximately 650 quadro benefits paid out of more than 43,000 benefit recipients. So, you know, so that's the universe. And you know, they're you know, again, they can negotiate, or the court could order different distributions and different things. Some of them, you know, but you know, we apply them as they come in.
Okay, and one last.
Follow up.
Thank you, Madam Chair. And so, do I remember my follow-up? And how many? I'm sorry, I forgot my
Okay.
follow-up.
Any other questions? So if I understand your testimony, you're saying that with a court order, you'll pay whatever is required. If the person returns to work and rejoins the system, there is no pension to be split, and the ex-spouse may have no other relationship with the pension system. When that person retires again, which I presume will happen, does the court order still apply?
It should, unless it was changed, because, you know, it governs when the distribution of a pension benefit. So when the person,
Oh,
you know, retires or retires again.
Okay, thank you. That's important to know. Yes, Representative Gould.
I collected my thoughts, thank you, and wrote them down this time. Okay, so when the retiree goes back to work, they are now, there's no active pension benefit in place because they are no longer withdrawing money out of the system and instead they're adding money into the system, correct?
Correct.
So my question goes to something Representative Lekis usually asks, which is cost to the system or the taxpayers or the workers. And that would be, wouldn't this fiscally be a benefit in a way that the retiree's gone back, but this person's still getting a set fee that they previously got? Am I making sense to you?
I think so, and I'll try to answer it, and if I'm going down the wrong path, but I mean, essentially, the members have always been allowed to return to full-time employment after retirement. An opportunity comes along, or whatever reason, there's a job that they feel is a good fit for them, and in that case, the pension stops and they're accruing additional service, they're contributing more money. So ultimately, the pension is going to be probably larger than it was, because, of the additional time they're putting in. So when they collect the benefit, there's more. It's somewhat neutral, cost-wise to the system for that, because if it was a full-time permanent position, somebody would be working in it. We'd still be getting contributions in the, yeah. So, but the carve out of the paying an allowance to someone else, I mean, that's just money coming out. There's no fiscal advantage to that, even if it was legally permissible, it's additional money. I mean, again, I understand, not firsthand, but I understand court cases can cost individuals a lot of money, but if the person is working full-time and making more of a salary, there may be an opportunity for the spouse to get a piece of that, to be made whole through that process.
Okay. Other questions? Yeah, Representative Blackus.
Thank you. So, given that this doesn't allocate any money to the retirement system for the cost, which I guess would be hard because it's not defined, but anything you did have to pay out under this, wouldn't that, in effect, after the readjustments, increase the unfunded accrued liability payments that all the employers in the state have to pay, even if it's by a little bit, but that's where the money would come from?
Yeah, I mean, it would be in the, farther out in the rounding if it's a one-off, but it may not be. We've got several hundred of these. I mean, certainly relationships end amicably or otherwise, and there could be other individuals affected by this, and if we're paying benefits to non-members or retirees, and it gets larger, then the plan qualification issue comes up again, as well as the funding issue.
Okay, thank you.
Other questions? Thank you very much. Representative Pearson?
Gotcha. Okay. Good morning. For the record, Representative Steve Pearson, Rockingham District 13, which encompasses Derry. I am not in favor or opposed to this bill. I wanted to especially hear what Mr. Carlin had to say. I want to bring up 2 points. The first point is that in the state of New Hampshire, a spouse can commit infidelity in this case and still, especially in Group 2, walk away with 50%, which I have a problem with. We are a state that does not recognize that as some other states do. So just keep in mind that that's a situation that can occur. The second thing here is that I'm concerned about where we're going down the road here, in the sense that if we start to dictate how things function, whether, in essence, we're not removing the ability of the employee to go back to work, but we're certainly tying something to it. My concern is that later on, we're going to get to the point where a spouse or a court will tell someone they can't retire, or they have to retire to provide a former spouse a benefit because they don't want to wait. So that's the problem here, is that I'm concerned about where we're going with this. based on the fact that we've had a system in place for quite a long time. So the conditions of Group 1 and Group 2 are different when it comes to divorce. So just please keep that in mind as well. Whereas in Group 1, you're going to have a settlement, you're going to have an agreement. Whereas in Group 2, the spouse automatically gets 50%, regardless of what that spouse did. So again, like I said, I'm not necessarily for or against. I have concerns now based on what Mr. Carlin said about the constitutionality of this, based on the way the retirement system is mentioned in our Constitution in Article 36 and in the general operation of the system in relationship to the IRS rules. I think that really requires some more deep look here to make sure that this is even possible, regardless of whether or not the House wants to do this or not. So that's where I am with that. I'm let's just call it caution.
Thank you. Representative Schmidt has a question.
Thank you, Madam Chair. So the question I have, it was already slightly addressed, but in reality, the system is already dealing with, I believe Mr. Carlin said something like 600.
I believe 600 out of 43,000. Yeah, for round numbers.
So we already have established at least a pattern of paying out, and I think we have to try to adhere to if it's a one-off in every case, that's 600 one-offs. That's not a system anymore. So could you address that issue?
I'll try, Peter, because I'm not entirely sure what you just asked me.
Thank you, Representative Pearson. I think we can all agree on that.
I'm not entirely sure. As far as does 650 events equal 650 individual one-off cases? Again, I'm not sure, because we would need to see the breakdown between Group 1 and Group 2 with that, because the conditions for the two groups as far as divorce are not equal.
Okay. Other questions? All right. Thank you very
Thank you,
much for your
Madam Chair.
testimony. Does anyone else wish to testify on House Bill 1435? Okay, then I will close the public hearing and go into executive session. Representative Schuett, you have a motion?
Madam Chair?
Mm-hmm.
Yes, I would like to move in expedient to legislate on House Bill 1435.
Is there a second? Representative Lekes, second.
Is that Lickers?
Do you wish to speak to your motion?
Yes, it appears that this would violate probably IRS rules, and state retirement system would be hard pressed to come up with a logistical reason to make such payments.
Representative Lekes?
Thank you. I agree. The only other comment I would have is that, I mean, if this is more than an extremely rare circumstance, the family courts could put some provision in the original agreement as to what should happen in the case that the pension goes away. I mean, I don't know that would take statute. It could just be practice in court. But if,
I believe the family court can make whatever stipulations they like.
right. So, I mean, if this is a big enough problem, then they could do something like that if they chose, or, it'd be good if we could do something to make civil court cheaper. But anyway, I agree with the ITL.
Representative Schmidt?
I agree with the motion. And the thing is that the courts are where you do individual dispositions based on individual circumstances, rather than having the statutes having to dance all over the place, I think is unwise. So as much as I can feel that it's an unfortunate circumstance, it's not for the legislature to deal with, it's for the courts to deal with, in my opinion.
Thank you. Anyone else? Comments? Questions? Representative Dolan?
Thank you, Madam Chair. We received testimony that this particular case, the male individual probably wanted to harm the constituent. through this action, I don't, while I don't disbelieve the testimony we received, I don't think we certainly don't have any independent evidence of that. And also, in this case, the individual confessed that they didn't have the ability to pay for the legal costs to take the individual to court. So if you think of the reverse of that, if this were to pass, then those who can bear the costs of going to court would no longer have to bear those costs. They would benefit from this change. So with that in mind, I agree with the inexpedient to legislate.
Anyone else? Representative Gould.
I just had a question on the statement that Representative Schuett made regarding breaking IRS rules. I didn't hear that testimony.
Mr.
Did I
Carlin
miss it?
commented on the fact that the IRS rules I believe, forbid making payments to someone who is not either a member or a beneficiary. Is that correct, Mr. Carlin? Yeah.
Okay, thank you.
Yeah. And the connection to the system is broken once the pension ends.
Could I please ask everybody to put their mouth near the microphone because it is incredibly difficult to hear. Please, thank you.
Okay. Yes, Representative Schmidt. He was going to.
Spoken like a true elderly person, I appreciate it.
Are there any other relevant comments? All right, seeing none, the motion is inexpedient to legislate by Representative Schuett. The clerk can call the roll.
Representative Lakis.
Yes.
Representative Dolan. Clerk votes yes. Representative Boyd.
Yes.
Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Schuett.
Yes.
Representative Gould.
Madam Chair, I have a process question. If I abstain, does that mean you don't have a
cannot
quorum?
abstain. You can vote no.
I very reluctantly vote yes.
Representative Smith.
Yes.
Representative Mangiaputi.
Yes.
And the chair.
Yes.
11 yea, 0 nay.
Okay. All right, that's 11 to, motion passes 11-0. Is there any objection to consent? Not seeing none, I will put this on consent. Representative Schuett, at your very earliest convenience, like today.
And so how did we go from 12 to 0 on the first to
Someone stepped out.
Madam Chair,
Yes,
just a
Rep.
clarification on 1292. I think it is 11 to 0.
No, it was 12 to 0. Who has stepped out?
Nobody stepped out.
No, 11?
Yeah.
Oh,
You said 12 after.
I said
Yeah.
12, but apparently I was wrong. Please excuse me. It's 11 to 0.
I'm looking around.
Yeah.
All right, thank you. Sorry, I was having a senior moment. All right, we have, it's 11, just about 11, time for the next hearing. We're out of executive session. And on House Bill 1352, Representative Grota is introducing it.
Thank you, Madam Chair. My name is Representative Jackie Grota. I represent the towns of Rockingham, of Rye, Greenland in District 24. I'm here to introduce House Bill 1352 for the prime sponsor relative to firefighting personal protective equipment. And with that, I ask you please to call Mr. Rill, who can give you more details about the bill. Thank you.
Okay. Representative Rill, oh, excuse me, not, Mr. Rill, sorry, excuse me. You are here.
Good morning, Madam Chair. Thank you for the promotion. I appreciate that. And good morning, members of the committee. For the record, my name is Brian Rill. I'm the president of the Professional Firefighters of New Hampshire. We represent approximately 2,000 active and retired firefighters throughout the state. I would like to thank Representative Grota for introducing House Bill 1352. This was a bill that we requested bipartisan sponsorship on based on a few factors. This bill does a few things here, and I'll just walk you through it. First, you'll see on line 10 of page 1, firefighting station wear has been defined. Nowhere in current statute, to my knowledge, is this something that is defined. Station wear, just for everyone's own knowledge, is essentially your uniforms that you wear day in and day out to the fire station, and you conduct all of your duties in, and then when you are responding to what we call an IDLH, or a situation that is immediately dangerous to life and health, that we then don our firefighter turnout protective equipment over the top of those uniforms. So we have defined what firefighter station wear is. If you look further down the page, the area of line 26, it clarifies some language that is in there. Currently, with firefighter PPE, I think it's well-known fact now that our personal protective equipment comes manufactured with PFAS chemicals actually built into it. It is in current law now that if that is the case, the manufacturer is required to supply a letter stating that the firefighter PPE contains PFAS chemicals, and that letter should be maintained in the employee's personnel file. What we're trying to do here is to put additional pressure on the manufacturing companies to do something about our turnout gear that has PFAS in it. Things are not happening at the rate that we'd like to see them happen at. So we want them to identify whether firefighters' turnout gear does or does not contain PFAS chemicals. Now, what's significant about this is there's currently no turnout gear on the market that has been tested scientifically and proven to not have PFAS chemicals in it. However, there are manufacturing companies that are claiming that their gear does not contain PFAS chemicals. What we're attempting to do here is to get the manufacturer on record to state whether the gear does or does not have those chemicals in it. Further, we'd like a letter not only to be placed in the employee's personnel file, but to ensure that there is proper documentation of this. The employee should also be provided the same documentation directly. And we do know, for reference, there are fire departments not intentionally doing so, but that are unaware that this law currently exists on the books. And we have found that some fire departments are not, in fact, supplying these letters in personnel files. So we want to, it's an additional layer of safety that we want to ensure that we take care of. On page 2 and line 9, there begins another piece to this. Because of the manufacturing industry and the pressures that we're putting on them on an international level, they are researching alternatives that do not have these chemicals in them. We would contest that when these new generation of firefighter turnout gear becomes available, that our fire departments should give preference to those specific articles that do not have the PFAS in them. Most departments, if not all, I believe all should have in place a routine gear replacement program. Firefighter turnout gear has a shelf life of 10 years. So if I were to get a set of turnout gear tomorrow, in theory, it needs to be replaced within 10 years. The request here is to make it such that if there is a new generation of turnout gear that is a safe alternative that becomes available during a department's normal replacement plan, that it would be given preference over the gear that is known to have be manufactured with intentionally added PFAS chemicals. until such time, and you look in subsection B, that a safe alternative is provided to the employee, we would ask that fire departments shall have in place a policy that limits unnecessary exposure to firefighting turnout gear. This is not to say that the normal day-to-day duties that we should not be wearing our turnout gear when it's most appropriate to do so. We acknowledge the fact that this is still the safest mechanism to protect our firefighters from an IDLH environment. What we're asking is that we limit exposures. For instance, firefighters out standing by a wire down or a power line down, potentially wearing their turnout gear because it's cold outside, or directing traffic in the snow with their coat on because it's cold outside or raining, or training in it that is not necessary for your job function. Some fire departments have allowed firefighters to don their firefighter PPE and go on a rower or a treadmill for exercise. There is training that we need to don this gear for. There's training that we don't. That is up to the fire chief, the management to determine what is necessary and what is not. So we would ask that there exists a policy in every department that makes that determination. And by January 1st, 2025, fire departments shall not have as an option for wearing a firefighter station wear that contains intentionally added PFAS, and I listed a few there. This is from a study from the International Association of Firefighters, where they determined that some of those uniforms that I spoke about earlier actually also contain fire-resistive chemicals that are carcinogenic in nature and giving our firefighters cancer. There are alternatives on the market. In fact, we used to wear them many, many years ago, and these would just be your organically treated cottons that do not have intentionally added chemicals. The trade-off that some might contest is that, okay, it doesn't protect you in superheated environments, and I think that that's fair. But I can tell you, in this day and age, the number of fires that our firefighters are exposed to have decreased, which is good on all fronts. But we're still wearing these uniforms every single day to do every single function. So we need to identify the risk versus benefit there. So that sums up all of the pieces of this bill. It's somewhat comprehensive, and I recognize that. I would like to address on page 2, line 10, if I could offer, and I've spoke with Representative Goley, who's the prime sponsor on this, a small amendment on page 10 to strike the words "shall be required to" and replace it with the word "should." And the reason for this is in conversations with some other stakeholders, there was a little bit of angst as to whether or not this created an unfunded mandate and or put fire departments in a position where we were asking them to do something that was unreasonable. Meaning, if there's a new generation of turnout gear that becomes available that does not have PFAS chemicals in it, but it lacks in other functionality that we need for the job, or the cost is extravagant, or the availability is too scarce based on every fire department in the nation trying to get at it. We don't want our firefighters walking around without some sort of turnout gear. As I mentioned, we still acknowledge the fact that it is the safest mechanism that we have in place to protect our members from an IDLH. So I would ask that amendment be submitted so that we would deal with those concerns. And I'd be happy to answer any questions you might have.
Thank you. Representative Gould.
Thank you, Madam Chair, and thank you for taking my question. My question is, having heard this testimony when we were addressing increased cancer screening because of the PFAS in the gear, turnout gear last year, and having so much of my family be firefighters and in administration in the firefighting field, it was shocking how many did not understand the risks that were in the PFAS. And I did quite a bit of research. So my question to you is, there seems to be a lot of very promising research on wool as being part of the solution in moving forward in second generation firefighting. Are you aware of that? And do you think that the people making these decisions that we're talking about, and by the way, I support the should instead of shall be language change, but are you aware whether this, how well people are staying on top of the trends and what's coming out for alternatives?
Thank you for your question, Representative. I'm extremely confident. We're a state affiliate of the International Association of Firefighters, which represents 343,000 firefighters across the United States and Canada. And this is, by and large, their number one issue that they're working towards right now. This has become a federal fight. And New Hampshire, by our cancer legislation that we passed last year with the presumptive law, and the cancer legislation that we saw supported in a Senate committee a couple of weeks ago, New Hampshire is on the map as one of, if not the most progressive state in the nation that's paying attention to this issue. So we are paying attention to the research. We are paying attention to the data that comes out of the research. And the International Association of Firefighters has run tests on both firefighter station wear and firefighting turnout gear. And they're working with the manufacturers to determine what the best alternative is. It's a little bit, the waters get a little bit muddied because there are 3 layers to firefighter turnout gear, and some layers with some manufacturers have PFAS in it, whereas others don't. But those others have PFAS in their other layers. So we're trying to find the ability to mix and match here.
Thank you.
Okay, thank you. Representative Dolan and then Shuett.
Thank you, Madam Chair. Thank you for taking my question. While I'm very concerned about the safety of our firefighters, and I do acknowledge the amendment that you're proposing, what I'm concerned about is during this period of transition from the old gear to the new gear without PFAS in it, is there any protection for municipalities from a legal standpoint that they don't get if they turn out their firefighters for incident, especially the more poorly funded departments in the state, or maybe volunteer forces or whatever, if they turn them out with PFAS contaminated equipment during this transit because they haven't had a chance to upgrade, what protects them from legal liability that they have introduced PFAS chemicals to these individuals? Is there any protection?
Thank you, Representative. My short answer would be I don't know the answer to that. But I would say that right now, as it stands, every fire department in the state of New Hampshire is acknowledging the fact that they're putting their firefighters in danger and at risk by mandatorily putting them in firefighter turnout gear that is laden with PFAS chemicals in all 3 layers. That is an acknowledgement now. And what I can tell you from an international perspective is that there are, they have watched this. We're all concerned about the same things. And the idea here is not to get anybody to violate a state law, but also we're trying to be reasonable in the language here to acknowledge the fact that this may not happen overnight. And we want to try and work with the employers to get it done as soon as possible.
Thank you. As a follow-up question,
Follow-up.
would you object to an amendment that limited the liability to the local municipality for this issue while we're in transition?
Representative Dolan, I think the requirement, the personal protective equipment replacement program implies that there will be a transition. But if you can think of some good legal language, well, that might make some sense.
Representative, I could tell you, I had a conversation yesterday about something similar, and we were talking about the gear replacement program. That's a replacement program that, although our shelf life has a 10-year lifespan, our administration within our fire departments determines what our gear replacement program will be. That happens now. That wouldn't be a change. So maybe the gear replacement program is 5 years, maybe it's 10, but there would be some ability for the chief, the department, and whatever elected body they have that oversees a budgetary need or whatever would be able to make the decision as to how to best implement the program.
Thank you.
Representative Schuett?
Thank you, Madam Chair. I call your attention to the bottom of the first page, lines 29 and 30. The added language and a copy of the same shall be provided directly to the employee. And I see a comma there. I don't mean this to be nitpicky. I'm serious. Was there supposed to be more language after that that inadvertently got deleted, or is that comma just a typo?
I believe it's just a typo.
Thank you.
Okay, put a period after that sentence. Representative Lacus?
Thank you. So I'm pretty sensitive to the unfunded mandate thing, so I appreciate the amendment you suggested, and certainly I couldn't have supported that without that, but I have a related question. So starting at line 18, it requires that they must not be provided the option of having stationware that has some of this stuff in it. And the question is, in general, I know it may vary, but in general, is the stationware paid by the employer or the employee? And if by the employer, how much is this going to cost? Because this has to be in place, as I understand it, by the beginning of next year. And if it's, most of the wear out there has these things, then all of it's going to have to be replaced this year, at least as I read this. And so how much is that going to be? Because that could be seen, I think, as an unfunded mandate to the municipalities.
Thank you, Representative. First and foremost, there is under current state law, and I can't cite it for you now, but I can certainly try and find it for you. A law which states that the employer must provide the uniforms if they require uniforms to be worn. What this does, and it's kind of in the fine print here, shall not provide as an option the wearing of. So essentially what happens right now in our fire departments is a firefighter gets in most cases, a uniform allowance, right? That may be $500 a year. And they're told you need to have navy blue pants, uniform shirts, whatever else, black boots, all these things. And in most cases, they are provided a list of optional items. If you want to buy a winter hat, if you want to buy a baseball hat, if you want to buy a sweatshirt, you can do these as an option. What we're saying here is the fire resistive clothing will not be allowed as an option for the employee to purchase. So it would be incumbent upon the employee to make sure that when they're using their uniform allowance, they're purchasing the right items.
Follow up?
Follow up?
Okay, so as I understand what you just said, that option is for the option of what they can purchase when they replace their existing clothing, uniforms, and they're going to buy new ones. However, this says it shall not provide as an option the wearing of firefighter station wear, which to me says that starting January 1st, they would be prohibited from wearing any existing uniforms they have if they contain any of these things, which means they would all need to be replaced. The ones that have that stuff in them would all need to be replaced before the end of the year. And so that is a mandate of replacing equipment that presumably would not need to be replaced that early, at least not for everybody. Thank you. I mean, is that my understanding correct? Or
yeah, your understanding is correct. I would say if the date needs to be amended, we can amend the date. I would be happy to do that. That would mean that, to my knowledge, there's no department that doesn't provide the uniform allowance on an annual basis. So that the passage of this law in theory, 1 year after that, you would be getting a new uniform allowance anyhow.
All right, thank you.
Okay? Yes, Representative Gould.
Thank you, Madam Chair. Just to follow up on that, I think I'm hearing two different things. If I understand correctly, Tony asked you if, starting on line 18, this bill would mandate that every department replace all turnout gear with non-PFAS.
No, this is not about turnout gear.
All right, so I know what that you're talking about, the $500 uniform allowance that employees get. So is that what you were questioning? Is that they not?
I understood this was the station wear and not the turnout gear, and that's what I
Okay.
was asking about.
All right. Okay, thank you.
Thanks.
Okay, Representative Mangiaputi?
Thank you, Madam Chair. Thank you for taking my question. So this applies to both fire departments in a city or a volunteer firefighter, correct? Anybody who's a firefighter in the state abides by this. And do the volunteer firefighters also get allowance to buy the gear?
I am unaware of how the volunteer firefighters operate, but to my knowledge, most volunteer fire departments would not get a uniform allowance, but they would then be provided with a shirt. Most don't have, in theory, a full uniform that they wear. This would be for the professional departments, the full-time departments.
Representative Pearson is volunteering to explain how volunteer fire departments deal with this. So if you could hold your question on that, since Mr. Rill doesn't know the answer. Representative Blackus.
Hopefully a brief thing related to that. So on the section starting on page 2, line 18, if it was changed to say something like, starting January 1, 2025, they shouldn't provide a purchase option for new clothing that contain that stuff. And then maybe at a later date, let's say 2026, beginning of 2026, they shouldn't require them to wear it or permit them to wear the clothing.
I would be supportive.
And
supportive of that.
follow up real quick. So do you know?
Follow up?
Okay, thank you. So is the cycle of replacement of this station wear typically like yearly? I mean, if they get the allotment yearly, do they typically turn over that stuff every year?
Yeah. There's really nothing proprietary about station wear. It's clothes that you could go buy at any department store. These are just treated with PFAS chemicals. That's the piece that we're trying to avoid. So if you think of it, no different than a suit you may wear here every day, at some point you're going to have to turn over those articles and buy new ones. So yes, I will tell you, in every fire department that I'm aware of across the state, people are replacing their uniforms on an annual basis.
Okay, thank you.
Other questions? All right, thank you very much. Representative Pearson?
Hi, thank you, ED&A. Good morning. For the record, Representative Steve Pearson, Rockingham District 13, which encompasses Derry. As many of you know, I've been in the fire service for 27 years, both in the paid career side of things and also in the volunteer side. So I can address a couple of things. And President Rill from the PFF&H gave you a great explanation of a holistic thing. I can provide you a practical day-to-day reality for me, and just to give my perspective from my own circumstances. As far as the volunteer fire service, it depends on if the volunteer department requires something specific. The second they do, now because they're still employees, under the labor rules, they are now required to have their uniforms either provided or a clothing allowance given to them. If the volunteer fire department does not have any sort of requirement as to what they wear, which generally they don't, because if you're cruising around in a pickup truck and the pager goes off, you're not going to rush home to change your clothes, right? So in those cases, you could be in jeans and a t-shirt, or I have fought fire in a suit, well, part of a suit before. So between the 2 weeks of my grandfather. So you never know what you're going to be wearing. So that's the differentiation there, Representative Lekis, is it has to do with is the requirement of the specific department. A lot of departments now, especially in Rockingham County and Hillsborough County, have day crews where they're hiring per diems, or they have some folks that might work a shift or two a week. In the cases of those folks having a required uniform, that absolutely falls under labor standard. Now the situation, and I'll give you an example of my own universe. For the first 15 or so years of my career, we wore Hanes cotton T-shirts that had silk screen on them. Hanes cotton T-shirts are not treated with PFAS at all. They're no different than any other T-shirt you can buy from any retailer. They would just have silk screen or embroidery put on them. And then we got a little bit more formal and went to a type of a collared shirt that was made by a company called 511 that provides uniform type shirts to law emergency services and others. Unfortunately, around a year and a half ago, we learned that the 511 products contain PFAS. I am still required to wear that shirt, despite the fact that for a very long time we wore Hanes cotton T-shirts or Fruit of the Loom cotton T-shirts. So as far as and we're talking station wear here, as far as the ability to acquire station wear that would get us out of this PFAS business, it's absolutely no burden of any kind. That Hanes cotton T-shirts they make by the millions, though that's not difficult at all. As far as and it's no different than the pants. I think that the main thing, of course, when you use the word uniform, is the definition of uniform, that all of your folks are the same. So, having been in this business prior to having a little bit more simple uniform, but certainly a PFAS-free one, that's not an issue. Now, as far as clothing allowances go, one of the things that my department has is a no excuse policy for uniforms that are unsightly, right? Because we have a clothing allowance. In my particular case, in the city of Manchester, it's every 6 months. So if you have a collar that's frayed or you have a button that's missing, there's no excuse for you, right? Because you get a clothing allowance and you are expected to have a proper uniform. So in this case, this enables, or it requires, I guess, kind of a little bit of both, the sense that with a dated line in the sand, we're going to do this now. Now, whereas that is a manufacturing issue for turnout gear, it is absolutely not an issue for station wear. And I hope that the committee doesn't confuse the two, because the circumstances under both of them are very, very different. So, as far as you're concerned about the unfunded mandate, I don't know that I view this in that sense, where their municipalities are already providing the funding to do this. They're just saying, hey, buy X versus Y. We're not going to give you more money. We're not changing our clothing allowance policies. We're just saying this is what we're going to go to. And we expect, as you receive your clothing allowance, that you will comply with this change.
Representative Lekis, you have a follow-up?
Yeah, thank you. I mean, do you see, I understand that, but do you see the issue that on line 18 on page 2, it requires two things to occur on the same day? One is they can't provide as an option, I guess to purchase, although it doesn't say this, the clothing that doesn't have the PFAS in it. But also, they're not allowed to wear it. So it's like the option to buy the non-PFAS stuff is provided on the same day. You're not allowed to wear the other stuff.
Sure.
So I don't oppose any of this. It just seems like that's a problem that needs to be fixed in the bill.
Sure.
I think I should mention here that this bill is going to go to subcommittee to correct the one change and look at this other section to make sure that it doesn't have unintended consequences.
Okay, that was my.
So I think
Yeah,
that-
I get what you're saying with that not having much of a difference. I can also tell you that, for this bill to go through the process and be successful, you will have fire departments immediately start the process of how they're going to be addressing this. They're not going to wait till January of 2025 to go, oh wait, now we have to.
Thank you.
right?
I mean, the bill says what it says.
Sure.
But thanks.
Yes. But I think with at least two sections where we need some wordsmithing, it needs to go to subcommittee to get that done. Okay, we'll go to the pension subcommittee. Representative Manjaputi and then Gould.
Thank you, Madam Chair. Thank you for taking my question. So you kind of clarified the distinction between volunteer firefighters and paid firefighter department. I just to further that, to clarify that, so the volunteer firefighter answering the call when they're driving someplace, they'll go straight to the location. But are they required to go to the station to get the station gear, or that's not a uniform thing?
That's not uniform. So some volunteer firefighters carry their gear with them in their vehicle and respond directly to the scene. Some report to the fire station to acquire gear and get on apparatus. There is no uniformity in the state with that. It varies from town to town. I will tell you that one of the things that I was always cognizant of as a volunteer firefighter is polyester. So polyester is bad news in this business. Bad news. So because when it melts to your flesh, they have to cut it off of you. And that, because of that, I kept a couple of things in the trunk of my car in the event. I'm not a big fan of polyester, despite what I'm wearing right now, but that's something that, that we have put into people's minds. Keep in mind that when things are on fire, the fire doesn't care if you get a paycheck or not. So, though we look at this from a career versus a volunteer standpoint, that line is not as important as some make it out to be, as far as, personal protective equipment and the requirements of the profession for the life of gear and whatnot.
Follow up?
Thank you. So from the protection of the firefighter, be it paid or volunteer firefighter, the gear should be a protective gear, the PPE that they are expected to wear in terms of fighting the fire. That should be a uniform protective gear, correct?
So the requirements and the conditions to which gear is manufactured is governed by the National Fire Protection Association, which is headquartered in Quincy, Mass. They have been the regulating body of that for 135 years now. So there is no differentiation in their universe between whether you get a paycheck to fight fire or not. That's irrelevant. Globe Manufacturing, which is one of the largest producers of gear in the United States, is in Pittsfield, New Hampshire. When you place an order with Globe, they don't ask you are you getting a volunteer set or a career set. You're getting gear. So I don't, let's not get overly hung up on the distinction of that, because the distinction really only applies in the case of whether or not you're wearing a duty uniform during the day or not.
Representative Gould.
Thank you, Madam Chair, and thank you for hearing my comment. It's really a comment, not a question, but you really helped.
Please, no comments in the guise of a question, just a question.
I just want to say that, all right, I'll ask you this. To me, it seems that we're talking about the exact same thing we went through for children with fire retardant chemicals on their pajamas that was outlawed years ago. Would you agree it's sort of the same?
Not at all.
Okay, well, thank you.
Not at all, because an infant is not losing 2.5 gallons of water out of their body sitting in a crib, I hope, unless they're next to the furnace. And that's the real big thing here is, of course, the biological effect of sweating and absorbing and what heat does to certain types of materials. That's the situation here. It's not, I wouldn't tie those two things together.
Follow up. Thank you for clarifying. It's even worse. My point was we protected babies years ago. We owe our firefighters much more today. Thank you.
Thank you, Madam Chair.
Okay. Any other questions? Thank you, Representative Pearson, for volunteering that information. Is there anyone else who wished to testify on House Bill 1435? I don't see anybody. So I will close the public hearing and open the hearing on House Bill 1079. And I believe Representative Prue will introduce it for us. 1079, excuse me. My mistake. 1079 is first, 1070 is a one. Sorry about that. I was confused. Thank you, Representative Prue, and he's bringing us an amendment. Oh, joy. Representative Prue, I see you're replacing a one-line insert with a 5-page amendment.
Yes, it grew exponentially. My name is Representative Mark Prue, representing Hillsborough 15. Good morning, Madam Chair and the rest of the committee. What started out as a quick changing or adding a definition. Let me give you a little history on critical incident stress management. I've been doing it for pretty close to 40 years. And for the longest time, I was the only team in New Hampshire. But now we're up to around 7. Some are police, some are combination. My team, the Granite State Critical Incident Stress Management Team, provides services to police, fire, EMS, pretty much any emergency responder. And we are now reaching out to include hospital emergency room staff, right? Because we pick up a bunch of crap on the street and we walk into the emergency room and dump that crap on their stretcher. So they run into the same chaos, the same stress responses that we do. And for the longest time, they had nobody to get this service from. So once I put in this bill, I heard from the police department, Southern New Hampshire police team, but they're also doing police, fire, and EMS now, that they thought while we're opening this up to, and what this really is doing for us is giving us the same protection that mental health providers have with their clients, right? It's confidential, can't subpoena it, all those things. So to do that, we have to have them listed in here. So we've opened up the definition. We're going to use the Homeland Security definition of first responders. And we're also going to add that hospital emergency room staff, which is on, I believe it's I on the second page. Yes, section I on the second page, to protect the confidentiality when we're working with the hospital staff. We also added retirees into the mix because they are an important part. One, for being able to deliver the service, but also receiving that service, right? We look at retirees that when they retire, they walk away from the support system that they had, right? When they're working, they can talk to their fellow fire, police, or whoever about what's going on with them, right? Because we share the same experiences. But when we walk away from our job, we walk away from that support system. And we find that our suicide rate in retirees is rapidly climbing because they're not getting these services. They don't feel they have access to them. And we want to make sure they know that they're covered. And we are working very hard to reach out to them as we speak to prevent that, right? Not only are our retirees' suicide rates climbing, but all the first responders are and I don't like to say it, but my statement is that we're kind of in a race with the military to see who can be on the top of that pile that nobody wants to be on. So we need to make sure that we can provide these services and that the people who are providing the services feel confident that what they say will be protected. Otherwise, they won't come. They will not come, right? Especially the police, right? Because some of the things that they deal with are pretty significant, right? Not that anybody else is less, but they get more scrutiny from their supervisors. Well, what did you say in there? Right? And it has happened in the past that supervisors had sat them down and said, we want to know what you said in there or what was said in there. And I know of one police officer that went to jail in contempt of court because he would not tell them what was said before we had this protection. So I don't want to see that happening because we missed somebody in the definitions here. So that's why there's a lot more added, and you will notice that a lot of it is just repeating the new definition in certain spots. And again, like you said, we added the hospital one. That's a completely new one that we really wanted to make sure. We're making sure that the 911 operators are included because they are not technically dispatchers. We had dispatchers. They are telecommunicators, right? They answer the phones, but they listen to some horrible things on the phone, right? And the imagination is a terrible, terrible thing. And I can tell you from experience. So I ask that we get this moved through to make sure our first responders are taken care of. And I have some other people that will also testify. But with that, I'll close my testimony and take questions if you have them.
Thank you. Are there any questions? Representative Groda?
I have a question of the chair. Is there someone from the New Hampshire Hospital Association that will be speaking?
I believe they are behind me, and that's where this definition came from.
Okay.
We had
If
one,
there is anyone here who plans to testify, please turn in a pink card so we know
mine's
who you
right here,
are.
sorry. I forgot to drop it on my way
Yes,
by.
but if there's someone from the hospital association or whatever,
So
I
they,
don't have any other cards on this bill, so please turn them in now.
I guess it's just me then. So that definition came from the hospital association. We had another one previously, and we had a meeting with them, and they didn't really like it and gave us the better definition. That's why that's what's in here now.
Thank you.
Okay. Any other questions for Representative Schmidt?
Thank you, Madam Chair. So it's just a, this is not a new bill, right?
No.
This is, it says it's an amendment, so
Yep.
you already brought us the original 1079.
Yep. So it's already in statute. It's been in statute for a long time. So we are just doing some housekeeping on that, making sure that all the people like retirees got covered, the telecommunicators got covered. And the only thing we're really adding is the hospital emergency room staff or emergency department staff.
I get that, but the thing is that this is not in the usual form. It's the unusual form of an amendment.
Yep.
The original bill came already earlier. Oh, great.
So that was
Never mind.
So that was my original amendment, just to add the hospital staff. And then I heard from other people who said, hey, while we have this going in, maybe we should add these things that we've been thinking about adding for a while, but didn't really want to open it up.
Others? Representative Mangiaputi?
Thank you, Madam Chair. Thank you, Representative, for taking my question. How does this differ from employee assistance or employee mental wellness
So
approach?
this differs as we are peer driven, right? So as far as I'm concerned, the person in the employees assistance program has no idea what my job is. None. Right? So when I tell them what's going on with me, they're going to go, what? We have mental health people on our teams. We make them ride in police cars, fire trucks, ambulances, and hang out with us, right? So we don't just go to any mental health provider because, frankly, unless they've been trained and know who we are, we scare the crap out of them. Quote, unquote, that I've been told from mental health professionals. You know, I've heard stories where someone would be in the middle of their story telling them what was going on. The mental health person would cry and walk out of the room. So that's why this is different. That's why this works for us, is that we're relating to people who have walked a mile in my shoes. So they know what I'm talking about and can help me get through it because they've probably been through it already.
Thank you. I noticed that you have a much better definition of what's confidential than in current statute, so thank you for that.
That was one of our goals.
All right, other questions? Thank you very much. Mr. Broughton?
Good morning, Madam Chair, members of the committee. Just for clarification, my name is Justin Breton, Breton. I am here in representing the Manchester Police Department, our peer support and CISD team, as well as a coordinator for our Southern New Hampshire Critical Incident Stress Management team, and the New Hampshire Police Association. I wanted to thank the committee this morning, first and foremost, for your attention to this very important update to our existing privileges and protections to this statute. Just a little bit of history. This was established back in 2012. So we have been very fortunate to have this protection for our employees since 2012. This has absolutely helped us save lives of countless first responders at this point. I'm sorry, that is my comfort dog partner. So he does therapy work in crisis response only. So he's going to might come check on everybody this morning. As I was saying, this is a very important piece of legislation that's helped us save countless lives at this point of New Hampshire's first responders, and we're extremely lucky to have this statute in place. Some of the edits that Mr. Prue was discussing are, like he said, and I'll use his term, a lot of it is housekeeping. Some of the terminology that you're seeing us look to correct with this edit is to reflect some of the work that we've been doing on the PTS committee and defining things and making sure that our New Hampshire first responders are protected and taken care of after they respond to critical incidents. So that's why you see some of the terminology changes that you do. As we talked about, and I'd like to address the representative's question in regards to the difference of peer support and EAP. I think that that's a very good question because there are many departments across the state and all of the first responder community that do have EAP programs stood up in place for their employees. What some members of this committee have heard us testify to in the past is that there are still some unfortunate barriers for first responder personnel to access EAP programs. I'm not sure if anybody in here has ever picked up the phone and had to make that call to an EAP, but I can assure you that it's a less than personable experience. Most of the time, the voice on the other end of the line isn't even from this part of the country. They don't know the department that you're calling from, and they have very limited ability to connect with the first responders that are reaching out to access and ask for help. Oftentimes, you're left waiting on the line for minutes at a time, hoping that the right person answers the phone to get you connected to the services that you need. And quite frankly, if you're in a crisis situation and you're reaching out and have to sit on hold listening to music and or a narrated prompt, most first responders are going to hang up the phone. And so what the peer support teams are doing across the state is we are genuinely the bridge that bridges the gap between culturally competent licensed community mental health providers and our peers. And I think it's essential that we continue to have the ability to do this, or we will continue to lose first responders to suicide in the state. I think I appreciate Representative McGuire bringing up the fact that a big portion of our modifications to this statute are really trying to clarify for everybody the limitations to this level of confidentiality, because it is important for that to be laid out very clearly for everybody. That starts on line 22 on the second page. And I think that, you know, these teams were, with the exception of Mr. Prue, and I say this with all due respect, in 2012, when we wrote this, we were all pretty young and we were new at this game. Representative Prue had a lot of experience at that time, and he's taken a lot of leadership along the way and mentored many of us as we've worked through and had a better understanding of how to do this work well. And so what we've heard from very many agencies across the state is they would like us to clarify for everybody the limitations of that confidentiality. I hope that when you read those edits, you'll see that this is truly a support service that's meant to protect not only our officers, but the community. This was initially something that was very important to have in there, so that way everybody believed in the system and how it worked. And knew that when the need arose, we were going to act and continue to get people help prevent crimes and make sure that people were connected to the appropriate services. So we greatly appreciate your time and the ability to clarify a couple of those points for the committee this morning.
Thank you. Are there any questions? Representative Mangiaputi.
Thank you, Madam Chair. Thank you for taking my question.
Yes, ma'am.
So since 2012, this was established, you said, the peer support. Is there any data or statistics to show the decline in suicide or adverse effect for first responders?
I wish there was a very good data set. I think what we have to acknowledge, not only as a profession, but also as a committee, is that these losses are unfortunately very underreported, not only in New Hampshire, but also across the state. We're actually doing some work on our PTS committee. Senator Birdsell just presented that to hopefully reinstate us for another session. And our hopes for this legislative session is to really focus on that. We've been having some very productive conversations on how we are going to collect that data so we can have a true understanding of the scope of the problem here in New Hampshire, and also be able to come forward and show that we are having a positive impact with these types of employee services programs. But unfortunately, there isn't a mechanism in place to accurately collect that data at this time.
Okay.
I can say that there is a nonprofit that's recognized nationally that does collect this data, and the numbers they are all relied on self-reporting. The numbers for last year were 118 law enforcement suicides across the country, and at least 25 in the fire department community. Also impacted by this and reflected in the statute are corrections personnel, emergency services dispatchers, and they are also impacted by the cultural barriers to accessing culturally competent community mental health.
Okay, thank you. Representative Brown?
Thank you, Madam Chair. Thanks for taking my question.
Yes, sir. Thank you.
Could you just more slowly tell me who you represent and what is the PTS committee? I missed all that.
Yes, sir. I'm sorry. As I said, my name is Justin Breton. I am an officer at the Manchester Police Department, and I also am here in representing New Hampshire Police Association, NHPA. I am the team coordinator for not only our in-house peer support team in Manchester, but I also am the coordinator for the Southern New Hampshire Critical Incident Stress Management team.
Thank you.
Okay. Other? Thank you very much. I don't see any other questions. Is there anybody else who wishes to testify on House Bill 1079? Somebody who didn't get my message? Okay, thank you.
Good morning, Madam Chair. For the record, Ben Bradley. I'm the Vice President of State Government Relations for the New Hampshire Hospital Association. I do not have prepared testimony for you this morning. However, I would like to express our support for the amendment from Representative Prue. I'm happy to take your questions.
Representative Mangiaputi?
Thank you, Madam Chair. What is your total number of emergency room employees? Does that include the physicians as well as everybody else in the department?
I do not have that information prepared for you this morning. I do not know.
Follow up.
Follow up?
Is that available readily?
I don't believe we have any standing reports from our members that would indicate the total number of emergency department personnel across the state.
Yes. I imagine it's fluctuating. Other questions? All right, thank you for your
Thank you.
testimony. Is there anyone else who wishes to testify? And I think since we have this amendment, we should send this to subcommittee also because, since we have one also. Mark's, excuse me, Matt's. Yep. Right. Okay, in that case, I'll close the public hearing on House Bill 1079. We resume at 1 p.m.
Thought that might be the case. First, I had to find the rule. Well, it's very grand.
All right, good afternoon. Welcome back. I'm trying to open the hearing on House Bill 1070, and I don't see any sponsors. Representative, you are a co-sponsor. Representative Lekis, would you please introduce this bill? Well, we'll give you a chance to chat since you won't be able to ask questions. You can answer them.
All right. A little out of breath, ran over here, but for the record, I'm Representative Tony Lekis, District Hillsborough 38, towns of Hudson and Litchfield. And this is related to dealing with the state of emergency. I mean, I know there were various concerns raised about the recent state of emergency and different views on it. But the idea here is to make sure that, to make it clear that no branch of the government should be involved in suspending civil liberties or of either the U.S. or the New Hampshire Constitution. Now, you'd think that would be obvious, but there were some things that went on that, could certainly have been viewed that way. The ones that I remember in particular were related to limiting what could be done in places of worship, churches, synagogues, that sort of thing, putting restrictions on them that was quite a bit more significant, even that on a lot of commercial establishments, big box stores, grocery stores, and things like that. So, there's some evidence that there was an actual problem, and this is in response to that. I'm not the prime sponsor on this, but I certainly support it. That's all I have.
Thank you. Are there questions from the committee? Representative Grota?
I guess I want some clarification because in the bill it says no state employee, department, or agency, but you mentioned churches and grocery stores. So where's the? Am I misunderstanding what you said? Can you speak closer to the microphone?
Oh, sure. Sorry. It's a little hard to tell how loud or not I am from here. The issue was enforcement that was taken against the churches and all of that by the state government, in particular requiring them to close or putting limitations on what they could do around having people attend during the COVID state of emergency. That's the relationship.
Thank you.
Yep.
Other questions? Representative Mangiaputi?
Thank you, Madam Chair. Thank you, Representative, for taking my question. COVID, public health was one emergency that you mentioned. Are there other example of emergency situation? Would it include floods and natural disaster situation where the state put an emergency?
Well, yeah, the typical emergencies are due to natural disasters, floods, ice storms, and that sort of thing. I mean, I could imagine you come up with scenarios where it could be an issue there, but I don't recall any situation where there's been a state of emergency that's the kind of normal weather-related one where this has been raised as an issue. So, and I don't want to get into doing some far-fetched hypothetical, but in the normal course of dealing with those emergencies, I don't know of any problem like that that's come up. It's more the, some wider, larger thing that's, a different sort of an emergency. And, I hope we never have another emergency other than the normal dealing with natural disasters. But given the experience, we'd like to make sure that that's not something that's going to happen in the future.
Okay. Representative Lekis, I have a question. RSA 445 Roman 3A says that notwithstanding the above, civil liberties shall on no account be suspended, nor shall the United States Constitution or the New Hampshire Constitution be suspended. So are you saying this is to tell every organization to follow the law?
I don't have that RSA in front of me, and I didn't draft this bill. You know, I can take a look at it and provide an answer to that. But you know, if the language is in the statute now, except enumerating the parts of the executive branch, then that might be the case.
Thank you. That's a point. Representative Schmidt?
Thank you, Madam Chair. So, thank you, Representative Lekis, for bringing this bill. And tell me, given the fact that the suggested addition to the statute was not yet in effect, can you give us some examples of occurrences that would have, in your view, violated this provision had it been in effect?
Well, first of all, as was asked by the chair, you know, this may already be something which, although in other words, is already illegal. If that's the case, then in my view, that part of the statute was violated during the COVID emergency. You know, there may be a number of things, but in particular, as religious institutions were dealt with, because they were required to close or had much more serious limits on them than other organizations like grocery stores or, you know, big box stores or any of that, which, so they were singled out, arguably, or at least there wasn't they weren't seen as important, and so there weren't concessions or accommodations made that were made for things like grocery stores and other types of things. And that's the concern. And so if this were in place there at that time, then yes, what was done would have violated this. Now, as the chair asked, it might be that it's already illegal, in which case statute was violated by that. Statute that was
I
existing at the
apologize
time.
if my question was repetitive, but given the fact that you were speaking so much softly,
I apologize.
in a large room,
Yep.
I wasn't quite sure I was picking up your meaning, and I don't ever want that
No,
to
I
happen.
understand. One of the problems here, sitting here, is it's hard to tell how quiet or loud I'm coming through the mic. So
I'll wave at you
apologize.
the next time.
Okay, thank you. Any other questions? Seeing none?
All right, thank you.
Thank you for your testimony. Is there anyone else who wishes to testify on House Bill 1070? Seeing none, I'll close the public hearing. Do you want to go into exec? Okay, thank you. We'll not exec this. In that case, our next hearing is at 1:45. Yes, sir.
As I can hear your voice to say, you are also soft-spoken, but the microphone, given the distance you are from the microphone and the acoustics, I use the word advisory,
Good afternoon. Welcome back to EDNA. Opening the hearing on House Bill 1267, and I call the prime sponsor, Representative Velcher.
Thank you, Madam Chair, and members of the committee. I have just provided a handout, which is Executive Order 23-03, signed by the governor on April 10th of last year. I would ask that you note that the language of my bill as submitted was taken verbatim from this executive order with only minor necessary modifications made. The term ESG is an industry standard term, and as such, it is well understood within the industry. I would note that the executive order, as signed last year, only prohibits investing in ESG funds if ESG is the sole reason for that investment. Now, the reality is that no funds are invested solely based on ESG. Technically, I don't believe that would even be an investment. It would be something else. And somehow, if somebody managed to do so, it would be virtually impossible to prove that. As such, the executive order is written and currently existing in rules is entirely unenforceable and makes no meaningful progress against fighting the ESG cartel. Now, why do I call it the ESG cartel? ESG exists as a public-private partnership that utilizes carrot-stick methods such as those employed by the Human Rights Campaign, where they are tasked with scoring organizations based on political and social activist criteria. These scores are then weaponized by a combination of public and private sector actors to limit access to capital for those who do not score high enough, and to reward those who do by directing mostly other people's retirement funds to these organizations. This process, in theory, could be said to make ESG profitable. But the reality is that it is a monopolistic cartel manipulating the free market. And the only profits that come are the ones that come through the weaponization of this carrot stick model. Also, in this manner, you will see why I did not choose to simply word my bill to prohibit anything, any kind of investing except that of those solely directed toward maximizing gains. Because of this cartel mechanism that is in place, a fund manager could credibly make the argument that by cooperating with the cartel activity, they are seeking to maximize gains because they are attempting to avoid the stick. In this manner, the ESG cartel represents the financial engine of the Cultural Revolution. The New Hampshire Constitution, under the section on inculcating values, outlines strictly that we as a body shall take all necessary measures to disrupt and crush anti-competitive, monopolistic, and cartel behaviors in the marketplace. This prohibition on ESG investing is easily distinguished from non-ESG investing. Simply put, those investments seeking to maximize gains without regard to the cartel activity and doing so in keeping with governmental regulatory frameworks do not represent ESG investing. Only those investments wherein gains are knowingly foregone toward activism, or wherein the only argument for maximizing gains is dependent on an expectation of the continuation of cartel activity to realize those gains. That is ESG investing. So, why attach a criminal penalty to this? When you seek to utilize these funds for which there is an expectation on the part of the investor that their gains will be maximized, to cooperate with the cartel and to prioritize social and political activism, you necessarily are purposely foregoing some unknowable amount of gains to accomplish this purpose. This is tantamount to fraud. And the funds we are discussing today represent such a substantial chunk of money that that degree of theft or fraud would easily clear the necessary amounts to be a felony offense. This is not their money to wield as a weapon against their opposition. This money belongs to the people who are expecting a retirement. And this is a common sense measure to protect that retirement. I'd be happy to take questions. Thank you.
Representative Lekis?
Thank you. So this question is related to why you believe this is necessary. I mean, in statute today, the retirement system can only do investments, related to their fiduciary responsibility. In other words, the best in return over whatever the appropriate time scale is consistent with acceptable risk. And I don't remember what it did in the Senate. We had a bill to require the treasurer to do the same thing for other funds. So given that, and given that, what you said about they're going to forego gains to accomplish some social activity, it would seem that, right now there is a prohibition against investing in things unless somehow, it's reasonable to believe and experience shows ongoing that it is in fact the best investment. And I ask that question even though I basically agree with your general view about ESG, but the question is, do we need to put something specifically about that in statute?
Thank you for the question. I would offer two avenues of response. First, as I said, fund managers could reasonably, under ESG guidelines, make a credible argument that they are seeking to maximize profit because they're looking to benefit from the monopolistic cartel activity that is occurring, and they're expecting that to continue into the future, which could produce a source of revenue that could be profitable. The second reason I would offer is because the executive branch believed that this was important enough to do something about. The unfortunate fact is their order is unenforceable, but that's what I'm seeking to fix.
Okay, thank you.
Need a follow-up?
I mean, the only follow-up would be that, realize that at least for the retirement system, they're required to actually do their own analysis and not just accept whatever's put out there by a fund manager. And so they're going to have their own fiduciary responsibility. Look into this and see if they believe that's actually true. So again, it just goes into asking whether this is really necessary.
Yes, I would offer, when I said fund manager, I should have been more expansive to say that any person managing such funds could credibly make this argument that because of the expectation of ongoing cartel activity, they could actually produce profit through this methodology, even though it's clearly against the New Hampshire provision in our Constitution against cartel and anti-free market behavior.
All right, thank you.
Any other questions? Thank you, Representative.
Thank you very much.
Representative Corcoran?
Could I just ask Representative Belcher, since you were giving us prepared remarks, would you be willing to share your remarks with the committee?
I would be happy to copy paste them in the email if that's sufficient.
That's fine.
Will
Thank
do.
you.
Representative Corcoran, co-sponsor of the bill. Thank you for your time. First of all, I'd like to just go on record as agreeing with everything that Representative Belcher said. There are two main arguments that I have against ESG, one of them moral, one of them utilitarian. The moral one is obvious, that if you are allowing a state employee to invest on something other than compounding retirees' funds as quickly as possible, you are deprioritizing what all of the employees, the retirees and current employees are looking forward to, and you are prioritizing a unelected, office worker to inject their own morals. Now, maybe those morals align with yours. Maybe the office worker is a member of the Knights of Columbus and they're going down some sort of Knights of Columbus approved groups that invest in, a certain Catholic led organization in Germany and this other, mining concern in Argentina and so forth and so on. In which case you're like, okay, this doesn't, horrify me. Probably some good is being done. Or perhaps the morals and ideology of the office worker are contrary to your own. A pro-life person might be very upset that their money is being invested in firms that take active steps in the other direction. I think that the culture war in the U.S. is already all-consuming enough that we do not need to have advocates showing up at these meetings saying, the governor has to fire so-and-so and put in someone else so that, my preferred investment strategy is used when we are sort of squandering some of our potential returns for retirees. If we default to just pragmatic mathematical, hey, let's, go into an index fund, hedge appropriately, et cetera, then this is an entire front in the culture war that we don't expand to, and we can just prioritize. I think we're all happy to live in a world where we can be confident that the roads outside are paved by the firm that put in the best quote, not the best quote from a firm that had politics similar to the, DPW commissioner. The second argument I have is utilitarian, and it just goes over some of the same space that Representative Belcher touched on, which is anytime you put in a second priority, you are deprioritizing the first issue. If we were running a symphony and we were looking for the best violinist in the world, that person is out there, and we can rank order. There's the top 10 or 15. But if we say, hey, let's get the best Albanian violinist, I'm sure Albania has some good violinists. It's even possible that the world's best violinist is Albanian. But probably, if we limit ourselves, the top violinist we're going to get is the 31st best violinist, and the next one is going to be the 73rd. That's just a simple matter of when you're looking in any data set and trying to, limit or filter by a certain thing, it is very unlikely that you're going to get as good results. That is, Representative Belcher did a great job, and so he stole about 80% of my lines. I'm happy to answer questions.
Thank you. Are there questions? Representative Blackus?
Thank you. This kind of relates to the earlier questions. You said that if you have more than one criteria, you're going to water down what the main goal is. Well, right now, the one and only criteria they're permitted is, the best return over the appropriate time period with a reasonable risk. Now, personally, I think the chance of an ESG fund having the best return, especially over the longer term, is extremely low. But still, if you're going to prohibit it, then you're, aren't you, removing that as an option for good return? And by the way, it's not the retirees that are going to be hurt; it's the taxpayers who are going to cover the gap. But
that's a great question, and I don't think it deals a good blow to the argument, but certainly it had some hoisted on petard. Or if I said, hey, if you filter away 99% of the funds, the remaining 1%, and you're saying, but if you filter away 1% of the funds, might that not have included the best funds? And that is true. However, given that ESG are a relatively small percentage of funds, and given that there have been studies showing that ESG funds consistently underperform, the criteria behind ESG funds are usually fairly restrictive. So they immediately knock out, sort of every defense contractor, every, small arms manufacturer, anyone who emits carbon. So you end up, first of all, as a percentage of all of the funds in the market, really radically constricting it. And then second, to the things that those funds invest in, so sort of a second order thing, are also hugely restricted. So while it is possible that just out of dumb luck, a particular ESG fund might be the best in the market, I think in the real world, you'd probably have to get, 2,000 years of returns before you'd find 1 year where it would have worked the other way.
I don't disagree. Thank you.
Don't argue with them, Representative Blackus. Are there any other questions? Thank you very much.
Thank you for your time.
Mr. Carlin?
Thank you, Madam Chair. Marty Carlin, representing the New Hampshire Retirement System. I do have some statement on House Bill 1267. I'm not going to read it entirely into the record, but I would like to refer to pieces of it and an initial comment about this bill. As many committee folks who've been on this committee for a while know, NHRS generally does not take a position on legislation regarding benefits, changes, things like that, or administration of the system. However, when there are fiduciary or plan qualification issues, the board may opt to oppose a bill. Our board hasn't had a chance to vote on this and another bill proposed in the Senate yet. They're meeting in a couple of weeks, but the legislative committee of the board, which was 5 of the 13 members, is going to be unanimously recommending to the board that they oppose this legislation on both fiduciary and plan qualification grounds. Generally speaking, we're not, the opposition isn't about ESG in a vacuum. It's generally any changes, legislative changes, mandates to the investment program could potentially limit or in some cases run counter to our fiduciary duty to act solely in the best interest of the membership at all times. Couple of statutory and constitutional citations I just want to put into the record is RSA 100A15(1)A A1, which as A15(1) is a definition of fiduciary duties that's modeled on the Internal Revenue Code. And it includes that the board and independent investment committee must make all decisions, quote, solely in the interest of participants and beneficiaries. Besides the statutory section, the Article 36A of the New Hampshire Constitution reads in part, all the assets, proceeds, and income therefrom from the New Hampshire retirement system, ... shall be held, invested, or dispersed in trust for the exclusive purpose of providing such benefits and shall not be encumbered for or diverted to any other purposes. So in English, the goal has always been to make prudent long-term investments to maximize value for our participants and for taxpayers in New Hampshire, and choose investments that give us the best chance of meeting or exceeding our assumed rate of return over the long term while balancing risk and liquidity concerns. ESG, which has multiple definitions. I don't think there's an agreed upon full definition for it, but regardless of whether you would say that, agree with that or not, neither ESG or any non-pecuniary factor is considered as an end unto itself in investment decisions. It's one of many factors viewed in regard to the potential impact on our ability to obtain the highest return. So it's not disqualifying and it's not qualifying. It's one of many factors. If you were going to take a trip across country, you wouldn't just look at the weather report. You'd look at the condition of your tires and what there's a lot of things that go into making an investment decision as a fiduciary, and this doesn't control anything. So any attempt to sort of limit the scope of finding the best financial opportunities to invest in for our members, whether it's investment, divestment, what have you, could constrain their fiduciary duty to act in the best interests at all times. Now, since there was a similar bill proposed last year in the House, House Bill 339, that was amended to a quarterly reporting requirement, and since that took effect for both Treasury and for NHRS, we've been submitting quarterly statements to the Legislative Budget Assistance Office that we're in compliance with our duty to make all investment decisions solely in the interests of the participants and do not have any investments in any fund that have mixed rather than sole investment in motivation. So not only are we doing it, we're certifying to it on a quarterly basis. This opposition in general, again, not to this specific bill about this specific topic, but opposition to legislative mandates involving investments is not new. Back in the 80s, there was a movement called the McBride Principles, where to divest from companies that weren't doing enough for underrepresented minorities in Northern Ireland, i.e. Catholics. And at the time, NHRS opposed that, and its external counsel made the point, which we continue to agree with, that using any other factor would mean we were no longer using the exclusive purpose of providing benefits as our sole investment motivation, and it would also be a divergent collateral purpose of affecting social or political change. So, in summary, we believe that this legislation could only limit our ability as fiduciaries to act solely in the best interests of our membership and maintain our status as a qualified pension trust. We believe existing law already serves that purpose, and this is unnecessary.
Thank you. Are there any questions? I'd like to say that I did receive the quarterly report from both the retirement system and the state treasurer that they are investing as appropriately as necessary. I'm on the list of designated recipients. All right, thank you, Mr. Carlin.
Thank you.
Hunter Hamberton.
Are y'all ready? Good afternoon. My name is Hunter Hamberlin. I'm the state policy manager for the Taxpayers Protection Alliance. TPA is a nonpartisan, nonprofit, consumer, and taxpayer watchdog organization. I would like to first start off by thanking Chairwoman McGuire and the rest of the committee members for allowing me to testify today. Respectfully, TPA opposes HB 1267, an act relating to prohibiting ESG standards in government investments. I've already submitted written testimony and a coalition letter in regards to this bill. And for the purposes of everybody's time, I'm just going to give the highlights. So first off, we believe this legislation to be arbitrary. As some of the other testifiers have said, there's already legislation on the books that kind of deals with this stuff. Specifically, the legislature passed HB 457 last year, and the governor passed an executive order to minimize risk and maximize returns on state investments. HB 1267 does not build on either of these policies, and it would do more harm than good. Second, there is no crime in investing in ESG, yet this bill would make it a felony to consider ESG criteria in certain state funds. Banning investment in ESG funds limits options for investors, as does mandating investment in ESG funds. Investment fund managers, like other testifiers have said, they have a legal and fiduciary responsibility to their clients already. Government involvement like this bill is unnecessary and counterproductive. Lastly, ideologically driven bans or mandates for funds to consider ESG standards only harm citizens' retirement accounts and waste taxpayer dollars. Pensions and investments should be protected from politicization, and we should not have bans or mandates on investment decisions that don't deal with maximizing the return. Any approach to ESG that is not neutral has the ability to harm taxpayers and consumers. TPA respectfully opposes this bill and respectfully requests that y'all reconsider this legislation. I thank you for your time, and I'm happy to answer any questions that I can.
Thank you. Are there any questions? Representative
Yes, sir.
Smith.
You seem to be presenting us with a prepared set of remarks. Have you
Yes, he has
afforded
given
us?
it to
Yes,
us.
sir. So I submitted written testimony, which is a little bit more specific, but this oral testimony it goes right from the written testimony.
Great, thank you.
Yes, sir. And then I also submitted this coalition, which kind of gives the principles on being neutral.
Thank you. Other questions? All right, thank you very much for your testimony.
Thank you all.
Michelle Veazey?
Good afternoon.
I'm Michelle Veazey. I am with New Hampshire Businesses for Social Responsibility, which is an organization of over 240 businesses in the state and as well as stakeholders who are interested in exactly the things that are compose ESG, the environmental, social, and governance factors. My testimony, which you have in writing, shares that ESG factors work to strengthen financial performance. If HB 1267 actually seeks to maximize return for state investment, ESG evaluation is designed to support that very goal. Too often, the acronyms become targets for partisan politics, and the true value or meaning of their use gets lost. ESG ratings are used to understand how a company is doing relative to others on important issues like protecting consumer data and privacy, worker training, chemical safety, executive compensation, and more. Would you want to know whether a company you're investing in has major financial risks because they're not properly managing contaminated wastewater? These are the basic measures that help professionals in financial management fields understand all of the risks and opportunities that might be material to long-term financial success. This kind of analysis is similar to the steps that a bank requires when any of us are trying to secure a mortgage on our homes, and we personally require in order to make sure that we're protecting our investment. Most of us would not consider signing on the dotted line before having a home inspector verify issues like lead, leaks, or mold, and certainly not without a clear title search. It's important to know that your investment starts off strong, or that you at least know what you're up against. Taking away tools that a financial professional deems important limits their ability to make the strongest possible decisions. Imagine that instead of buying a home, you're responsible for investing millions, even billions of dollars on behalf of other people. And not just the dollars for any people, the retirement savings of hardworking public employees. Should those be limited to just short-term profits? Or should you take into consideration the risks a company might face in the future or other factors known to materially impact a firm's long-term financial performance and ability to thrive in a rapidly changing world? ESG is used because it provides value both to companies trying to assess their own progress, which is why 90% of the S&P companies create ESG reports, and more importantly, they're valuable to investors. Understanding a company's environmental track record, how it treats its workforce, and the transparency of its financial controls allow for both responsible and profitable investing. For these reasons, we encourage this committee to vote to oppose HB 1267. Thank you, and I'm happy to take questions if there are any.
Thank you. I don't see any, so thank you for your testimony. James Monahan.
Thank you, Madam Chair, members of the committee. My name is Jim Monahan with the DuPont Group. I'm here today on behalf of Ceres, which is a national nonprofit organization with many members in New Hampshire focused on sustainability in the business community. We are opposed to House Bill 1267. And as is my practice, oftentimes in bills like this, I start from the back of the bill and work my way up. And the fiscal note, I think, is quite telling. And the representatives of the Retirement Fund, I think, did an admirable job of walking the committee through the challenges that it would create, which informed the fiscal note. As I work my way back up through the bill, I also was, it has been mentioned here, but I think it strikes me as a relatively extreme provision of the bill, and that is creating a felony that would imprison somebody for up to 20 years for undertaking their work, fulfilling their fiduciary responsibility. I had presented testimony to you from Ceres, and I won't read that to you, but I will attempt to summarize it and answer any questions that you all might have. in essence, what the bill is doing is asking the state government to interfere with the financial professional's judgment and fiduciary responsibility. As has been stated by others here today, the consideration of ESG is a part of that fiduciary responsibility and shouldn't be disposed of with a government constraint. As was also mentioned, this is not a brand new issue to the legislature and this committee. We dealt with it last year with House Bill 457, and I think a good compromise was struck there where it reinforced the obligation to act in a fiduciarily responsible way and provide information to the chairman of the committee and others in a reporting process, and that seems to be working well. Finally, this is not the only state where this issue has arisen in recent years. In Indiana last year, for example, there was a legislative commission that looked at the issue and determined that it created a $6.7 billion would create a $6.7 billion financial loss to the state pension plans. And then also in recent years, fiscal notes from Arkansas, Kansas, North Dakota, Texas, and Wyoming have raised similar concerns about the risk that bills like this would put on pension funds. So I've handed in the testimony. I'm happy to answer any questions, get the committee additional information if they need it. But in conclusion, we are opposed to House Bill 1267.
Thank you. Are there any questions? Seeing none, thank you very much. Deborah Hawes?
Good afternoon, Chair McGuire, and yep, have to get closer. Thank you.
Louder, yes.
Okay, good afternoon, Chair McGuire and members of the House ED&A Committee. This is my first time testifying before this committee, so I am happy to be here, and thank you for hearing my testimony. I'm here on behalf of the American Federation of Teachers New Hampshire. On behalf of our 3,700 members across the state, we are teachers, paraeducators, town employees, university faculty. We are those public employees that are in the retirement system, and we've got thousands of retirees in the state as well. So we do have an interest in how the funds of the state retirement system are invested. We are opposing this bill. We are opposing it because it would place an artificial limit on how the retirement system balances risk versus the healthy rate of return that the state expects from the money in the retirement system. We are concerned that it would get in the way of appropriately evaluating risk on anything that has to do with environment, social, or governance issues. You really want to know when you're investing in a company whether there's a huge exposure to lawsuits due to their environmental policies or something they've manufactured in the past. It would be bad to invest because they're profitable now, but there's a ton of lawsuits coming down the pipeline. You want to know that ahead of time. So we do not feel that this bill allows for the appropriate balancing of interests when you are making investments of money that eventually is coming out of our members' pockets and needs to be paid back to the retirees when they retire. Forcing divestment from ESG funds has not worked in the other states that have passed bills like this. As another testifier mentioned, in Arkansas, there's been a loss of 30 to 40 million a year. So that's less revenue their retirement system is taking in than they expected before they passed a bill like this. Our members who pay into the New Hampshire retirement system with every single paycheck, they pay their portion of it. They expect to be able to retire with dignity after a lifetime of service to their communities. They're out there working again as teachers, as police, as town employees, and they pay in every single paycheck. They expect the money to be invested wisely, to balance that risk and the return, and to have the bargain upheld when they retire. So for that reason, we oppose this. And thank you for listening to my testimony. I will email it. I didn't have a chance to print it.
Thank you.
Thank you.
We will look forward to it. Are there any questions?
Okay.
Seeing none, excellent. Is there anyone else who wishes to testify on House Bill 1267?
Thank you very much. My name is M. Friedrichs, and I am with 350 NH. We are a climate justice organization. I wanted to start out by reading a list of companies. AT&T, Bank of America, Fannie Mae, Freddie Mac, Fifth Third Bank, Allstate, American Family Insurance, Redfin, Realtor.com, Estately, the National Association of Realtors, the Consumer Financial Protection Bureau, KPMG, Brookings, Huntington, Norges Bank, Homes.com, the Legal Services Corporation, and most recently, the U.S. Congress. Now, I share that list because that is a limited list of just some of the bodies that are currently using data from Risk Factor Foundation. Risk Factor, which is a product of the First Street Foundation. And that data set is data that looks at climate risk and what may happen to properties. So thus you see the large concentration of real estate, bank, and insurance entities on that list of clients. Now, we are seeing a huge movement towards industries beginning to pay attention to what climate risk may mean for their investments. When we were looking for homes in New Hampshire, we used Realtor.com and Redfin as some of the real estate guiding platforms. And we looked at their risk factor before deciding which home to purchase. So we knew that our major investment as a family would not be compromised as climate change begins to become more and more apparent in our state with flooding and other issues. I bring this all up because climate change risk is one of the very important aspects that is covered under an ESG qualifications report. And not all anti-ESG movements or policies are particularly focused on denying climate change, but some of them are. And we believe that is a huge disadvantage to New Hampshire residents and to particularly our New Hampshire pensioners to not be able to take into account the realistic risks that come into play with climate change. And one of the important ways of doing that is through looking at the ESG criteria. That is all that I came prepared to share today. I'd be happy to take a question if there are any.
Thank you. Are there any questions? Representative Mangiaputi?
Madam Chair, I just need your name.
Yes, it's M. Friedrichs.
Thank you.
It's easy. All right, I don't see any other questions, so thank you for your testimony. Anyone else? All right, then I'm going to close the public hearing on House Bill 1267, and we have 7 minutes. Okay, so we go into executive session. Representative Broda, did you say you have an amendment, a motion?
Oopsie, I do have a motion. I move ITL on House Bill 1267.
No, second.
Okay. Representative Broda, do you wish to speak to your motion?
Yes. What motivates me to present this motion to the committee is that the New Hampshire retirement system has its own investment criteria, and that should be the one that we support. And it should not, we should not be swayed by testimony on either side directing our attention to one thing or another. And the New Hampshire retirement system it has this covered, and their investment strategies are the ones that are geared to benefit those who participate in that fund.
Okay, Representative Blackus?
I agree with Representative Grota. And what I'll add is, although I tend to be on the same side of this of the whole ESG thing is the sponsors. You know, everybody has their own thing that they consider important, and but you know, trying to use the investment of the pension system to promote or oppose any particular thing. In deference to Representative Grota, I will not use the term slippery slope, but I will say it's a very bad precedent, and it's not something we should be doing.
Any other comments, questions? Okay, in that case, the motion is inexpedient to legislate, and the clerk can call the roll.
Representative Lakers.
Yes.
Representative Bailey.
Yes.
Representative Dolan. Representative Gerhard. Clerk votes yes. Representative Boyd.
Yes.
Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Schuett.
Yes.
Representative Gould.
Yes.
Representative Smith.
Yes.
Representative Mangiaputi.
Yes.
And the chair.
Yes.
13 yeas, 0 nay.
Okay, the motion passes 13-0. Does anyone object to consent? All right, seeing none, we'll put that on consent. And we have 4 minutes before the next hearing. Please, yeah, do this. Okay.
So Carol, is Glenn gonna chair or are you gonna chair this?
Tony. He's next up in line.
Oh, okay. And so, can we go into executive session?
Fine by me.
Okay. If you want to go into executive session, this is Carol Bell. Unless I will, we're gonna support that. We're saying
I was the chair of a commission on the retirement system. House Bill 1451 is a recommendation from that commission. I am not sure if I personally support it or oppose it, but I think it is important enough that it should be brought to the legislature and debated. So what it does is that it declares that for pension purposes, mandatory overtime is included in base pay. The reason for that is that right now, overtime is included in your pension only up to a certain percentage. There are specific calculations about how to do it. But with the recruitment and other issues we have, some employees are working a great deal of overtime mandated by their employer. Because you can't leave your police station unattended, you can't not have workers in corrections, you can't not have people in the state hospital to keep an eye on the patients there. So this says that for pension purposes, the employer-defined overtime is base pay. The employer definition is important because that eliminates the possibility of someone manipulating their overtime to spike their pensions, which is one of the reasons why overtime is limited. If the employer says you've got to work tonight, that's not your choice. You're not doing it to inflate your pension. You're doing it because somebody's got to be there. Thank you, Representative Schmidt. So, as I said, this allows the full amount of any mandatory overtime to be included in base pay, which will increase pensions to some degree for those people who are forced to work overtime. It is already paid for because the employee and the employer both make contributions on the payroll, not on base pay. So there will be a fiscal impact, of course, but it's less than it might be otherwise. And I think it's an issue of fairness to the employees. I'll try to answer any questions.
So any questions from the committee? Representative Mangiapudi.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. It's very specifically says mandatory, which means the employee has no choice at this point. So from that point of, they're not doing it to beef up their base pay for pension, correct? So it seems like a logical, fair thing to say. They've done their due diligence. They've served when they're asked to. So they have to be compensated for that.
Yes, they are paid, and including overtime. Overtime pay is in their contracts, but beyond a certain level, overtime is not necessarily included in their pension. And for some people, it can be significant. The Department of Corrections, for example, is working significant overtime and has for the last few years that I'm sure of, and probably before that.
Follow up?
Thank you. Similarly, the LNAs in county nursing homes where the acute shortage of personnel.
If the employer decides it's mandatory overtime, that's what would be included. Right now, as I believe Mr. Carlin will explain, the employer reports base pay and then other pay, which are handled differently. But this would just put the mandatory overtime into the base pay line.
Representative Schmidt.
Thank you, Mr. Chairman. Representative McGuire, you cited in your testimony a couple of examples of state entities like corrections and state hospital where you simply have to have somebody there all the time, and that's going to involve mandatory overtime. Have you looked at what the total the total the total employer panoply is with regard to how many are going to be impacted by this
I
change in the
haven't
statute?
examined it in great detail, but I'm pretty sure that teachers don't get much overtime. There are a few state employees that do. The snowplow drivers, for example, work overtime. But I am sure that there are some places where it is required to keep staff on hand. And
Well, I
those-
totally agree with you. I'm just
And that
wondering.
is the places where there will be mandatory overtime. They're
you.
largely police, fire, corrections, and a small amount in places like New Hampshire Hospital. The nursing homes, maybe, I hadn't thought about that, but that may be another case where you have to keep people on hand.
Absolutely. Thank you.
Any other questions? Okay, see none, thank you. Next, Mr. Carlin.
Thank you. Excuse me. Thank you, Mr. Chair. Marty Carlin, representing the New Hampshire retirement system, and back in the familiar position of not having the retirement system not having a position on this proposal, which is a policy decision. As Representative McGuire said already, since the changes made in 2011 to the pension system, members who weren't vested by January 1st of 2012 have had their pay reported differently. Folks who were vested prior to that, everything was base pay. Everything that was listed as earnable compensation in the statute was treated as base pay. For the folks who weren't vested, and as well as current and future recent hires, the employer is reporting base pay as one line in the monthly report, and then compensation over base. That includes, but is not limited to, overtime, any kind of annual attendance bonuses, if there was workers' compensation, supplemental pay, longevity pay, things like that. So, and that's not broken out by type within comp over base. The law also calculates pension benefits under the average final compensation. It's a 5-year average, and it looks at the percentage of compensation over base pay versus base pay in the total, in the bottom line as a percentage in each year since the data has been available, so since 2012. And then there's a formula that if the percentage of compensation over base in the high 5 years is lower than higher than the percentage in the other years, it is the lower percentage is applied. So it could serve to reduce. There's some variations with group 2 and group 1 in that, but just for the purposes of this discussion, that's how it would work. So we see this bill prospectively as employers would be determining whether overtime is mandatory or not, and reporting it in the base pay line to NHRS going forward if they make that determination. A proposal like this is extremely hard, if not impossible, to put a price tag on, because we don't know how many employers are going to define it overtime, how much overtime people are actually getting in any of the 4 groups now, because it's not broken out as a separate entity as well, and how future economic trends are going to affect this benefit. So it's almost like it's going to have to play out over time actuarially based on experience. I mean, I think Representative McGuire is 100% correct in saying that probably the group least affected by a bill like this is going to be teachers, because they tend to be contract employees working a set number of weeks. There isn't a lot of overtime in my experience with educators, but besides public safety, group 2, again, highway workers, county nurse, places where they need coverage, they need a set amount of people, they are probably employers may be forced to mandate people work extra shifts just because of workforce issues and other things. So it's sort of hard to pin down what this would cost, but I'd be glad to answer any questions anybody has.
Thank you. I've got a few actually, to start with. One is Representative McGuire mentioned, as I understood it, that the amount the employers are contributing both for the normal cost and presumably the amount they pay to cover the unfunded liability is based on total payroll. And so they're already paying based on the amount they're paying in overtime as well as everything else. Is that correct?
That is correct.
Okay. And then, presumably there will be some amount extra paid out in pensions. And, am I correct that any such cost is going to end up increasing the unfunded liability and therefore increasing the amount that all the employers have to pay for that portion of what they pay into the pension system?
It will increase the costs. I'm not sure how much of that is unfunded versus present value of future benefits, normal cost type things. But yes, to the extent that any individual benefits from this change such that their lifetime benefit's going to be larger, that those funds aren't accounted for. So they would be paid through future employer contribution rates.
Yeah, just kind of a follow-up on that. Since they're already paying, the employers are already paying the amount, and the employees for that matter, I guess, are paying the amount based on their total payroll. This won't cause that to go up at all. So whether it's called unfunded liability or what, it's still going to come out of that portion of what the employers are paying. Is that right?
It'll start showing up in future employer rates over time as experience, in your retirement experience. But there's no immediate, way to value this and then, the next rate setting valuation. But over time, if this increases, if this proposal in the aggregate increases benefits by 0.05% for members or 5%, that's the variable that we will need to monitor.
Okay. And then the last one is, I think, almost asking you to get your Ouija board out. But I guess the thing is there any guess, at least the order of magnitude of what the total cost, $1 million, 10 million, 100 million, any? I understand the difficulties, but
so again, this is employer defined mandatory overtime. So the closest thing, and this isn't apples to apples. I mean, this is why it's not in the handout. But if you recall, a couple weeks ago, this committee heard House Bill 1653, and that made overtime for Group 2 Tier B members part of base pay. So that was that cohort of about the 1,650 members in Group 2. And the fiscal note on that, I believe, had a rate increase that would equate out to about $3.4 million a year overall on the Group 2 contributions for state and local employees. So this isn't apples to apples, but that's a peg on the battleship board to give you an idea.
okay, thank you for that attempt. I don't know who was first, but I guess I saw Representative Mangiapudi first, and then Grota, and then Gould.
Thank you, Mr. Chair. Thank you for taking my question.
She had hers up earlier.
This is, I'm not saying this would affect him one way or the other, but would you consider that this would help retention and workforce longevity in a place where it's employer asking for a mandatory overtime? So there's the investment from the employee to do the overtime, and employer asking, and there's a reward for the employee for giving up their time when they didn't ask for it. Yeah. So would that convert into a longevity or workforce retention?
Yeah, I don't think NHRS is qualified to give a definite opinion on that. Unfortunately, I mean, that was one of the considerations in the Retirement Benefits Commission that this came out of. That was part of the discussion there. I don't know if there's anybody here from the Municipal Association or the school boards or the counties who might have more insight closer to the actual employer base than we are.
Representative Grota?
Yes, I just want to. Do you believe that mandatory overtime is defined enough in our system so that we know how it would be calculated? Is there enough understanding of what mandatory overtime means so that we don't have discrepancies between departments?
Well, I think the goal of this is to give the employer the control. So mandatory is in the eye of the employer. So there is no standard definition of mandatory because the employer is going to weigh that and decide.
Follow up? Yep.
So, because I know nothing about, I just want to understand mandatory overtime. Let's say that someone needs to fill a slot and there's two people that raise their hand. Does it become mandatory overtime since two people are offering to work? You see how this can get fuzzy?
Absolutely, Representative. That's a good example. I'm not really versed well enough to make that. Ultimately, it's going to be up to the employer. I mean, I think either through a personnel policy or collectively bargained a definition, on an employer by employer basis.
Okay, Representative Gould.
My questions were exactly what Representative Grody asked, and having been in those shoes as an employer and an employee, I think it's very fuzzy. I think it's something to be concerned about with this.
I mean, one thing NHRS would monitor through, random employer audits and things like that is whatever the policy is, that it's consistently applied to all members and all groups. Because if it, it is carve outs and things that could down the road become a plain qualification thing, but just, a consistent application of a standard is something we would try to require from employers. So it's not arbitrary.
Yep.
Thank you.
Representative Grota.
So this, is this consistent application? Is that something then, how would that happen? I mean, how could it, do you have rulemaking or any authority or anything like that to mandate that?
Again, compliance with the statute, I think just in general terms would require consistency. But I think, mechanically, we would probably create a form that the board could approve for an employer to submit, to say we're reporting overtime as mandatory or not. So we'd have a record of who's doing it and who's not. If, Manchester does and Nashua doesn't or something like that, we would want to know, as long as all the apples in the Manchester bucket are apples and all the oranges and that, type of thing. So I think we would look for some declaration or statement or attestation from an employer as to what they're doing, so that there's no ambiguity going forward with folks retiring from that employer when the time comes. And again, this doesn't affect overtime paid over the career before the effective date of the bill. We wouldn't be able to unscramble that egg. So this is only accrual payment of overtime going forward.
Any other questions from the committee? Representative Mangiapudi.
Thank you, Madam Chair. Thank you, Madam Chair, and thank you for taking my another question. So this is only for moving forward, not the ones that are there already in the system, right?
Yeah, we wouldn't have the data to be able to go backwards and say what was mandatory. After, no employer has defined it yet as mandatory, so it would only be from the point when they can start doing that.
Follow up?
So in that case, defining what mandatory, it has to come from the employee and the employer and the need of the hour. Is that something that can be kind of defined?
I might refer back to the sponsor on the intent of the bill, but as defined by the employer is pretty broad. It doesn't have criteria in which to make that determination. It's just the proper body for that employer making that determination based on whatever facts they want to factor into it. So it is, and I don't see anything in the bill now that has a checklist or steps to define what's mandatory. It's,
Okay. Any other questions for Mr. Carlin? Okay, see none. Thank you.
Thank you.
And I'd like to call Bryn Rill I've got the name correctly. Oh, Brian. Ah. The A's and N's look the same.
That's Representative Bryn Rill.
Ah, Representative. It
No.
doesn't say that.
I'm teasing. That was from earlier.
All right, sorry.
My joke didn't land.
I
Thank you,
apologize
Mr.
for not
Chair.
recognizing all 400 of us.
For the record, Brian Rill, President of the Professional Firefighters in New Hampshire. Thank you, committee, for hearing my testimony this morning. I speak obviously in support of this bill. I'd like to thank Representative McGuire for bringing this forward. I really appreciated the time in the commission working alongside her on this. The reason why the professional firefighters think that this is important is, I've heard it a couple times already. The recruitment and retention issue in our state is not getting better. And we need to find creative ways to move forward on this issue. This is not a restoration of a benefit from the past, although at one point, overtime was considered base compensation and it was all included in your base calculation. This is a modified restoration, if you will, in that we're not asking for every stitch of overtime to be included back into base compensation. We're trying to be realistic with the ask here in that, a firefighter, a police officer, a correctional officer, if they're required to be at work, they shouldn't then be penalized on the back end for that. And that's our position on this. And just to give you an example, a firefighter wakes up ill on Christmas morning and can't come to work, and another firefighter then has to stay and is unable to go home to their families. They're required to stay, and then their retirement calculation suffers because of that. Now I understand it's a minor one-time situation, but this happens on nights, weekends, holidays. This is time away from families. This is forced time on the job, and it's hours worked most of all. It is actual hours worked on the job that they should be compensated for. So I would ask for the committee's support at looking into this further. And I'd be happy to answer any questions.
Representative Schmidt and then Representative Mangiapudi.
You ready, Brian?
I'm ready.
Thank you, Mr. Chairman. So, in a sense, this is mandatory overtime in the examples, some of the examples you gave for sure. Would that be something that could be worked into this bill? Because if you got to stay on the job, you got to stay on the job, because public safety is involved, especially in the case of troopers. Then they shouldn't be penalized for that. So, is that something you would entertain if it were workable?
Representative, I'm sorry. I guess I missed the question in there. Are you talking about holidays specifically?
I'm talking about any time a trooper is on duty and cannot leave.
I see.
Because the scene of the accident, just think in the wintertime, you got a horrific accident. Those troopers are going to stay until the job is done.
Sure. Yes, I think
that's mandatory. They didn't get an option. Anybody here want to work overtime, in a factory or something like that? They got to stay. So why shouldn't that be part of the reach of this bill?
yes, I would be supportive of that. I think I don't want to get too much into the weeds, because I think that the defining of mandatory overtime removes being in the business myself. It removes a lot of the ambiguity, whether that be through, as mentioned by Mr. Carlin earlier, department policy, department procedure, the fire chiefs making that determination, collective bargaining agreements. In many cases, the city or town identifies what that staffing model looks like and requires you to maintain a minimum staffing. So in different municipalities, it may vary as to what they're defining mandatory. But that's what we're trying to do here is be consistent within those municipalities.
Representative Mangiapudi.
Thank you, Mr. Chair. Thank you for taking my question. You kind of partly answered my question in terms of mandatory because it's the need, and this will also provide the workforce that's needed today. If you don't have 5 firefighters to serve in the community today, one of the firefighters have to do an overtime to fill in the fourth position, right? So how do you define that in, and you kind of said it goes from community to community, it gets the municipality what they set the standard. So from that point, with the concern of not being able to hire, retain, would this add to the toolbox of workforce retention and providing adequate workforce for today's need?
Thank you for your question. I can't say with any amount of certainty, but I do believe that it is a piece of the puzzle. And it's a piece that when we look at what we believe to be the lowest hanging fruit, that it makes the most sense. This is truly a fairness issue. And when we talk about the inability to go home and live our regular lives because we swore an oath, we have an obligation to protect our communities. And we take that very seriously, but also we do have lives too, and we have families, and we have other obligations that we're not able to attend to because we're being forced to be held. And if I could give you an example, just as a way this may work, right? In the community I work in, we staff at 15 firefighters per shift. The fire chief has determined that the minimum staffing for the fire department is 13 firefighters. So if 2 firefighters take the day off, no harm, no foul. No one's mandatory forced into work. If a 3rd firefighter takes the day off the same day, then someone needs to fill that seat. They've determined that 13 firefighters is the lowest minimum staffing standard to maintain a safe work environment for our firefighters. So that's what the fire chief has determined as being the safest staffing model. It doesn't work that way in every community, but that's why it's so important to allow it to be defined by the department.
Representative Grota.
Hi, I'm Ms. Drill. I support the fairness issue, and in principle, I support the bill. I just would like to know, is there a way of further defining what mandatory, when you speak about it, it makes sense, right? It doesn't come to work, so the person that's working on the night shift or the day shift or whatever shift it was has to cover for that other shift. So is there a definition of what that is? My previous example where somebody doesn't come to work, but there's 2 people that are willing to fill that slot, that's not really mandatory that's not mandatory overtime because either one of them is willing to do it. So can you help me understand that better, or am I just picking at something that can't be defined further?
I guess, thank you, Representative, for your question. My hypothetical question would be, would it matter, because it doesn't matter if you have to pay employee A or employee B to fill that mandatory spot, it's still going to cost a certain percentage, right? And it's going to calculate to a certain percentage in someone's overtime. I guess the simplest way of putting it would be the example I just gave, in that however it's determined, whether it be through collective bargaining or city policy or the fire chief's management rights, there is a minimum staffing standard for every department that must be maintained. And to me, the simplest way of putting it is if it falls below that, then that would be mandatory overtime.
Follow up?
Thank you. I think with your help on that, and so really in this case, the employer could be a municipality, correct? So they're going to determine for themselves through their collective bargaining agreements with their employers or employees how this is going to be managed. So thank you. I think I'm settled.
Sure.
I think I'm okay.
Representative Dolan.
Thank you, Mr. Chairman. Would you be willing to, the confusion about mandatory overtime, would you be willing to submit an amendment that gave a definition of mandatory overtime to be added to the bill?
I would be happy to have those conversations. I would prefer to have that conversation with Representative McGuire, who wrote the bill, and
Okay, thank you.
but I wouldn't be opposed to wordsmithing it if that's what we need to do.
Representative Gould.
Thank you, Mr. Chair, and thank you for taking my question. Your previous statement, response to Representative Grody, was also very helpful to me. And to me, one of the things that jumped out was the mandatory nature is based on the need of the opening that exists. So the mandatory is attached to the position. If a volunteer happens to be available to volunteer to do that, they're filling a mandatory need. And if nobody volunteers, then somebody's going to appoint a body to do it, to fill a mandatory need. So I'm wondering if that might be a consideration to put into the rewording somehow, that the mandatory, and as you pointed out, you can't write a definition that's going to fit every single instance because you have so many different, whether it's a residential program that has to be staffed 24/7, a hospital, a fire department, a municipality, a state-run, they all have different, probably, definitions. Does that make sense?
Yes, thank you, Representative. It makes sense to me, and I think that you hit the nail on the head in that it's a mandatory need, and that is going to be defined differently in every single city and town, and in every single discipline, whether it be fire, police, the hospitals, whatever. At some point, it is defined somewhere as to what a minimum level of acceptable staffing is, right? Otherwise, you could potentially have a fire department with 2 people working when they're supposed to have 15. So certainly we could work on some language if that's acceptable.
Any other questions? Okay, seeing none. Thank you.
Thank you.
And I'd like to call Sean Thomas.
Thank you, Mr. Chair and members of the committee. Thank you for this opportunity. My name is Sean Thomas. I'm with Demers and Praisall, and we represent the New Hampshire Police Association as well as the New Hampshire Troopers Association. I expect, and it's at least my goal, that this is the shortest testimony you hear all day. But President Mike Geha with the Police Association, President Frank Campo with the Troopers Association, both wanted to be with you today. Unfortunately, they couldn't make it and asked me to let you know on the record that for the reasons you already heard from Brian Rill, that this is a very, very important issue, and they strongly support House Bill 1451 and respectfully request your support. Thank you.
Okay. Any questions? Seeing none, thank you.
Thank you very much.
And I call Representative Steve Pearson.
Thank you, Mr. Chair. Again, for the record, Representative Steve Pearson, Rockingham District 13, which encompasses the town of Derry. As this is something that will affect my operations as a firefighter in New Hampshire, I'll disclose that as a member of the retirement system. So in listening to the testimony and the questions that were asked, as far as the language of the bill, let me bring it, as I have with other things, to just where the rubber meets the road here, right? So you have a situation where in a lot of communities you have a staffing level, and as Mr. Rill stated in Portsmouth, the way they do it, where they can go down too. Now, to muddy the blanket definition part of this a little bit more, right? So the city of Manchester is required to have 46. So you have sometimes the threshold there is a lot greater. You have the ability to have at any one time 16 people off on a shift. 16. So I've been there 21 years. I have been forced to work at 21 years on a mandatory shift. So what does that mean, right? That means that I didn't go home or didn't get to come to Concord to go to my niece's birthday party. Almost missed a flight once. Mandatory overtime. And as I have stated in the testimony in the other overtime bill, this is doing the same work on Tuesday that I'm doing on Wednesday, and yet you're treating the exact same amount of work differently. Except in this case, a governmental agency is telling me I have to stay at work or there are penalties. This is not a simple, you don't get to go home. Let's look at what this really is. But when you're forcing someone to work, you are doing it against their will. And I want that to sink in here. Okay? There's a governmental agency forcing a person under penalty of discipline or the loss of a job that they must stay. And I think that changes this game tremendously when you're talking about that. And it's certainly why, at a minimum, it should be treated like any other shift as far as the calculations go. Now, this isn't free. The employee and the employer pay their portion as they would for the shift the day before. So this isn't coming out of, there's no magical pot of money this has to come out of. This is coming right out of the checks as it was before. So I want to make sure we understand that as well. This, as far as that aspect goes. Now, as far as the request for kind of an overall blanket definition of this, I think we got to be careful here because as a person who believes in local control, as I do, if we start to mess with the local control aspect of this, we're going to run into a situation where we have a definition that does not work for everybody. As an example, in the case of Mr. Rill's department in Portsmouth, they can go down 2 people before they have to hire. My department can't go down anybody. Except that we have units in the city of Manchester that are required to be filled, and we have units in Manchester Fire that are not required to be filled. We have a squad unit that is not required to be staffed. So we're going to have to be careful here. If we decide to do a blanket definition statewide and take away local control, that we're not either forcing a municipality into something they don't want to do from the sake of having to retain people, or we're forcing a municipality to not keep someone. I think the local control aspect of this is a critical part here. And that's just the fire service wise. I can't speak for how corrections and law enforcement operate, but communities have different needs. They have different staffing levels. They have different philosophies. They have different tolerances. I can tell you a volunteer department that I worked per diem for 20 years ago, if no one showed up that day, they just went with nobody. They didn't went with anybody, which was a little shocking to some of the residents there, but that was reality. So where does that fall into play? Now, are you forcing this town to create a mandatory minimum that they just currently don't have? So I just urge caution when it comes to a blanket definition of what this would be as far as local control goes. The other thing I want to remind the committee here is that overtime, because of the way our salary and benefit structures now work, overtime saves municipalities money because they're not paying, which is now mostly 60% of someone's compensation package is benefits. You don't get extra dental for showing up on an overtime shift. So let's not lose sight of that. That game has changed a little bit here. And where we have municipalities right now that are running short to save money, they're slightly exacerbating the potential of mandatory overtime shifts. Now, as far as recruitment and retention goes, We had an individual who was hired by Manchester Fire who quit after his first shift because he was getting held mandatory and had a newborn. Now, I think there's probably a little bit of a failure to explain to that individual that the magnitude of what a mandatory overtime shift is and the fact that he would be subject to that. But the point is, we lost an employee over this. So where we are so scarce and so desperate for human resources right now, to get into a situation where you enter into employment in New Hampshire in the emergency services and you live in the world of potential mandatory overtime, but oh, by the way, we're not going to compensate you the same way for this forced action that we will for the shift that you had the day before, you can see where that's going to be a little problematic. And it costs us an employee. The concept of it costs us an employee. So that's where I'm going with this. And I just hope that those factors can be taken into consideration when drafting the parameters that you seem to be asking for.
Okay. I have one question for clarification, then Representative Schmidt. So if you have a department that's trying to save money by having fewer employees but more overtime, I mean, is it that something that's scheduled ahead of time and people know they're going to have to do it, so it's not mandatory overtime, or is it handled as mandatory overtime?
That would depend on the department. There are cases, I'm not familiar with every single department in the state at all, not even close. But I know of cases where the handling of mandatory overtime is very different from department to department.
Okay.
So there is no blanket process or way that that's conducted.
Okay. Representative Schmidt.
Thank you, Mr. Chairman. So I'm as strong an advocate as you are for local control. And you mentioned this in your testimony a couple of days ago, if you recall. One day you're working this category, the next day you're doing the same job, but it's a different category. But the reality is that it's kind of a dog-eat-dog world out there where one town is picking off employees from anywhere else to get them because they need them. And they're making a better offer to that employee for whatever reason, whether it's because it's a shorter commute or better pay, whatever. But to the degree that the mandatory overtime would be different, would work out differently in Town A than Town B, because Town A is paying more generous basis of whatever than Town B is, well, that's the luck of the draw. And in terms of Town A having that situation and Town B not having it, or vice versa. So why is that necessarily? I understand that there's lots of complexities here, and it's kind of like, I don't have to give you examples, you understand. Why is it necessarily a deal breaker to go for mandatory overtime where it's going to work out differently in some of the towns and others?
Sure. In the case of the individual that we lost in Manchester, his boots landed on a department that didn't have it.
Right.
They just didn't do it. They ran down to zero,
which
does not serve the public. In my opinion, does not serve the public in any way. But people's life situations are very different. Some people have a lot of flexibility, some do not. Where we have a department in the state where a mandatory overtime could be traded off to someone. That is not my department. My department does not allow that. So, in the whole crust of local control, right? We don't have a standard pay for a police officer in New Hampshire. Municipalities determine that pay. We don't have a standard pay for a teacher. We don't have standard pay, right, for any local entity. Those conditions are set by the municipalities, and they battle it out for human resources and duke it out for the limited folks that unfortunately we have today. So again, the maintaining of local control in this regard is no different. That they can set a situation that can attract or not attract an employee. So like I said, I'm just urging caution if we're trying to have a statewide definition and taking that away from local control.
Any other questions? Okay, seeing none, thank you.
Thank you, Mr. Chair.
Is there anyone else here who wishes to speak on House Bill 1451? Okay, seeing none, I'm going to close the hearing on that. And hang on. All right, is the chair coming back up, or are you staying out there? Okay. All right, so you're still okay with executive now? What? See what?
Are you saying that we can't go into executive session?
Yeah, 1, 2, 3, 4, 5, 6, 7, 8, 9. 10. We have a quorum even without. Yeah.
All right. What's up? Fine. All right, we've had a request to go into executive session. Is there a motion?
Yes, Madam Chair, I move auto pass on House Bill 1451.
All right, Representative Groder, do you wish to speak to your motion?
Yes, I apologize to the committee if I took us down the lost path of defining mandatory overtime, but I think that the testimony that we heard after that helped me come to the conclusion that really the municipalities are the employers and are the ones who are going to be responsible for this, and that is their decision, and therefore it should remain there.
Representative Gold, do you wish to speak to your second?
No, I totally agree with what Representative Grody has said.
Representative Blackus?
Thank you. I think I'll support the OTP, but yeah, there are some concerns that while in one sense the local employers are responsible, the money's coming out of the pension fund, and that is going to be paid for by all employers. And although, as was mentioned, there was a mention that the money's already being paid because they're paying on overtime. The reality, though, is in effect that's kind of a donation to the pension system because benefits aren't paid on that, and you could say that's not just and it should be fixed. And I might agree with that, but it's still going to be an additional cost that we're putting on the employers. So I'm not entirely happy, but and a little concerned about 28A issues, but I think I can go along with it.
Yes, all right. And anyone else? I would agree that trying to define mandatory would be an exercise in futility because each employer would have different ideas of what is mandatory overtime. Some of it is, I'm sure, is decided by collective bargaining, but others may not be. It may just be. Right, and that's why this, or one of the reasons this bill explicitly says it's the employer's call on what's mandatory. Because they know the conditions that's in and they know that they're demanding overtime. Anyone else? Representative Lekis, you have any other comments, questions? In that case,
not pertinent to
the motion is ought to pass by Representative Groda, and the clerk can call the roll.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Dolan. Representative Gerhard.
Yes.
Clerk votes yes. Representative Boyd.
Yes.
Representative Groda.
Yes.
Representative Schmidt.
Yes.
Representative Schuett.
Yes.
Representative Gould.
Yes.
Representative Smith.
Yes.
And the chair.
Yes.
12 yea, 0 nay.
All right. Does anyone object to consent? All right, seeing none, we'll put it on consent. And thank you all for participating. And close the executive session. And now we have some subcommittees.
actually kind of hard to hear from here up to the other end of the room. So, and it's a little friendlier. All right, we had thought we were going. Is this Lee Webster by any chance? No, that's a representative. Never mind. We thought we were going to hear from someone who was well versed in this subject. However, they are not present.
Didn't we get some written testimony or email testimony?
Yes, I do have clarifications that the prime sponsor, Ms. Representative Lamontagne, sent. Did everyone get that?
Mm-hmm.
Okay. I will state that I believe there are still quite a few questions revolving around this issue, and where a lot of your testimony previously and in the submitted clarification refers to green burials. I will point out this is not technically green burials. It's not alkaline hydrolysis. Green burials are, in fact, permitted by statute now. So this is technically a whole new concept that we're looking at. I will say that for myself, I was kind of perplexed that the states that have adopted this have not been able to craft rules addressing regulating it yet. And I'd kind of like to see kind of how those models look before we actually do that in New Hampshire. Did you have any other concerns?
Well, that was part of it. And I was concerned about the cemetery operator that felt that compost, if they wanted to call it that, would be regulated by some federal agency, which I'm really don't want to impose on anybody. And I'm concerned that some people that are apparently in the business don't seem to want to use the same terminology. So it doesn't sound like this is a unified accepted process. I think that since green burials are already allowed and there are green cemeteries in the state, I think there's not much urgency to working on natural organic reduction, which sounds moderately unnatural to me. So I'm not inclined to want to pass this bill immediately.
I will add that I had the opportunity to talk to the representative of the New Hampshire Farm Bureau, who informed me that there are folks in the state that do animal composting, and that does require permitting. And sorry, but we are technically animals. We're from the animal kingdom. So I think that particular aspect is going to have to be addressed, among other things. And I think what we would like to see is for the sponsors of this bill to look at a lot of the questions that were raised during the hearing. And we're talking about probably putting this into interim study to give you folks time to investigate and answer some of those issues and see if you can come back with something that will satisfy the needs for this legislation, probably after the close of session or possibly even at the end of summer, which is when we would be acting on interim study bills. And we can schedule another meeting, a work session on it if you think you have some things that satisfy some of the issues, so that we can discuss it if you care to. Representative Schmidt.
Thank you, Madam Chairman. So I totally agree that there are too many unresolved issues. I definitely don't think the bill is ready to pass at this time. By the same token, I think it would be the wrong step to say ITL because I think there a lot of thought has gone into where you are already, this place or that place, nationwide or nationally anyway, so I think the obvious place to go is to do interim study to work on it because it definitely needs work, but I don't think it would be fair to the process and to the developers and so forth of this concept to just say, go away and don't bother us, which is kind of what an ITL does. So I would support an interim study motion. Cut right to the chase.
I agree with all the statements, and Carol, Representative McGuire put my thoughts into play perfectly. I think there's way too many questionable variables involved with this, and I think things need to be clarified. I think everyone should have the right to, if someone wants this type of burial for themselves, but what if they're not able to, say they pass away and they weren't able to suggest that? I mean, there's just way too many things that I'm uncomfortable with this event. I think that needs to be further discussed.
Worked on anyway, for sure.
For sure.
Okay, well, let's do it.
Would anyone here like to address this? Yeah, go ahead.
I just wanted to clarify that in Washington State, it is regulated and it's regulated through their Office of Professional Licensing. And so they require testing of the final product for heavy metals and pathogens. And once they've gone through that process 100 times, then they bumped it down to 25% of the time it has to be tested. So they do have a process in place and it is underway there and working, I think, quite smoothly. And so, and I agree.
Are you speaking particularly about cremation?
No,
now?
no,
This
natural
is-
organic
okay,
reduction.
thank you.
This is about natural organic reduction. So they have a Department of Ecology, I guess, where we have a DES, and their Department of Ecology said this is not our purview, and had the Office of Professional Licensure there do it. So I do think there's a question in play as to who wants to take on that role in our state and making sure that's done, and we're happy to dig into that further. I think the question raised by Life Forest, I'm not sure where she's headed with that. She reached out to USDA for their organic standards, but you would never go through that process in this situation. It's not an organic product that anyone's trying to sell in fact, it's explicit in our bill that it is not to be used for agricultural purposes. So I don't think that that's an issue, your concern about the federal requirements. But again, if we have time to work on it now, we can certainly clarify that for you. Do you have?
Yeah. Yes, and it's certainly not an agricultural product. That it seemed that this group from Light Forest kind of went off on their own tangent about this, and no other state is the Department of Agriculture involved in regulating natural organic reduction. It is regulated by the same agency that regulates funeral homes and inspects funeral homes and any other and cremation. So that they would bring the Department of Agriculture into this discussion was really, no one else is doing that. But likewise with, you wondered if you need a permit to do composting of animals on a farm, it wouldn't be the USDA who would do that. But in our bill, we clearly lay out that if someone's going to bring their remains of their loved one to be treated at a NOR facility, they would have to get a certificate the same way that they would to bring a body to a crematory. It's the same process.
Thank you. Well, like I said, I literally just bumped into this friend of mine who I know works at the Farm Bureau. So I asked him, and he said he would look into it. He, off the top of his head, he wasn't totally familiar with their statutes and so forth and rules, but he was going to look into it. I can give you his contact information. And yeah, yeah. Okay. Yeah, it's Rob Johnson. So, yeah. And, like I said, I just literally bumped into him in the hall and just said, well, hey, do you know? So,
It might be that
one of the things that comes to my mind also, I think members of the committee were all shocked when you talked about the large amount of product that's produced as compared to cremation. A truck bed full as compared to a 6 or 7 pound canister of ashes. And it was suggested, the family may want a little portion of that, but I think we need to talk about or figure out what could be done to dispose of the rest of that properly if the family doesn't want to claim it.
or even if they only want a small amount.
Yeah, which I would think.
Would be more common occurrence.
Yeah.
In Washington was saying, as you just said, some people will take a small portion and then donate the remainder, and that's where someplace like Life Forest would eventually come into play. But again, she said they test it, they're required to test it by their Office of Professional Licensure. Then the receiving facility is not. There's no expectation that they would test it again. So it's been determined to be safe, and then a memorial garden forest would take it.
Right.
You're going to keep talking, I think you're.
Oh, I'm sorry.
Oh,
Well,
yeah, that's true.
Okay, thank you.
But the point is,
No, I understand.
we're being recorded, only you're not.
Well, the other difference, like Life Forest is a little different from a cemetery. If they were to take the soil from natural organic reduction, it's not as though they're burying a person, because at this point, the soil is soil. There's really it's not human remains anymore. And we did try to address the ways that the soil might be distributed or dispersed in the cemetery chapter. And likewise, it's pretty common that people accept that ashes from cremation, people can do whatever they want with them. There's no regulation at all. We did try to define what was a scattering garden or a memorial forest if someone was setting up a place specifically to accept those things. If they were going to say, yes, we're going to take your ashes here and put them in a place with a marker for the person, then they are acting more like a cemetery, right? But if they are taking the ashes or the NOR soil with no marker whatsoever, then they're just taking this material and using it to help regenerate a forest, but they're not acting as a cemetery. So that's kind of the difference there. But we did try to address that, and I agree that maybe we could work on that.
I mean, I believe that was why the Archdiocese objected, because they said that you're not treating the remains with proper respect, even if they have been combined with other elements and matured into soil, it's still part of a person. I don't think if you said, okay, we're going to use the soil that the families don't want and build a berm in front of our facility, you wouldn't get much support for it. I think people want to know that even if it's been degraded and processed, it's still treated with respect.
Absolutely, I think that's true. One of the things that I noted in the piece that you sent us, I don't know if it was last night or this morning. Item 3. Well, it's like the second item 3 says any NHDES has stated they would not require any special regulations for NOR soil. But then further down under 5, you state that easement from future developments should follow best practices as defined by the Department of Environmental Services. So there's a little conflict there that needs to be ironed out.
That was a reference to an easement, though, to like protection of the land. Yeah. Yeah, I think the latter was, the intention was to have remains go someplace where it would be in perpetuity a park or a reserve place, not suddenly built into houses in 10 years. So that was the intention there, different from DES regulating the actual product or soil. So
I would also, yes, well, I just want to say I would urge you folks to reach out to the funeral directors group and take input from them. And I'm asking if you would care to have any input into this, the funeral directors. Do we have? Okay, yeah, all right, yes, okay, yes, thank you. Would you, yes, yes, please come. Thank you. Because that was one of the concerns also, is whether or not the community cemeteries would have to like do special ordinances or something to allow this in their facilities.
Right, and for the record, yeah, my name's Mike Horn. I'm Secretary Treasurer of the New Hampshire Cemetery Association, which have about 120 members and represent 40 associated towns. And we became aware of this back in mid-January and couldn't make the hearing before. And we had a board meeting this morning, and I said, I'll be in Concord. I'll come here to speak. And we're hoping to meet with the representatives and have them come to our April meeting to speak to the cemeterians, of which we'll have probably 75 people there, and to learn more about what's being proposed, and hopefully we can help craft the language and make it something that everybody can agree with. We weren't looking so much at the natural organic reduction. There was even some concern on getting more definitions in the state RSAs about green burials and other stuff, of which we struggle with, but we just wanted to have our input considered, and we did one of the representatives was connected to our vice president, but they didn't have time to connect and collaborate before this hearing. So
Thank you very much for coming. I would urge you to
Yeah, we'll
exchange
talk.
information with Representative
Right.
Lamontagne, and
okay,
yeah,
so
thank you.
thank you.
It would not be enacted this year, but what we would do is, if you come back to us with something that we feel is workable, we would recommend it for legislation in the next biennium.
I'm a first term rep, so I don't understand the process very well. But would we meet again with the committee or do
Yes,
we just?
to be honest, it's up to the committee, and some committees don't take it very seriously. But EDNA has the bad habit of actually working on most of our interim study.
Okay.
So we would expect to meet with the interested parties to answer some of the questions and resolve some of the hanging issues.
Okay, so we would do our homework and come back with some new ideas and bring everyone to the table for a session.
Yes, if we choose to have another subcommittee meeting, it would be broadcast to you as this notice was sent to you as sponsors. And we would probably notify the interested parties as well to come to see what kind of compromise you may have reached.
Okay.
And then eventually the full committee will have to vote on whether or not we recommend future legislation.
Okay,
So
thank
you
you.
have like 2 bites of the apple coming still.
Okay, thank you.
Throw in too, like,
Okay.
I am a Christian minister, and I have a huge problem with this, sir. So, I'm a Christian minister, and so I just want to be fair and let you know I do have a problem with this bill. We can say, you put a body in, it comes out, that this is not human brains. It is. So I do have a problem with the bill. I'm just being honest. So take that in consideration.
Okay, well. Okay. Well.
Right, we're talking, this is the subcommittee meeting for House Bill 1486, which talks about proxy carbon pricing and state procurement. So I think the reason why we called this subcommittee meeting was because, frankly, the hearing had a lot of extra stuff in it, which made it very confusing. So I'm hoping you can tell us what the bill is about and what it means. Well, what it's about. What would you like the state to do, and what would it do? How would it be effective? I guess that's what we need to know.
Oh, thank you very much, Madam Chair. And for the record, I'm Nick Germana, state rep from Keene, District 1, Cheshire 1. So the idea behind this bill is to have the state make purchasing decisions that are in the best interest of taxpayers, and also keeps in mind, in this case, the pricing of carbon as a part of the formula that the state uses. So I appreciate the opportunity to talk to the subcommittee, because I think the discussion in the original hearing got off topic into much larger questions about carbon pricing in general and carbon taxes and consumer behavior. I think good questions were asked there about, those kind of larger issues, but this bill is specifically about state purchasing decisions. It's not about a carbon tax. It's not about trying to influence consumer behavior across the state or the region or any of those things. It's saying that looking at the energy landscape right now, we see that Canada has adopted a carbon pricing model. The European Union has adopted a carbon pricing model, right? That is going to eventually end up somehow working into our system, because these are enormous trading partners for the United States. And so we get put at an economic disadvantage when we're working within a different system than they are. We're going to be paying carbon taxes from Canada and the European Union. There will be penalties in all likelihood applied to American companies exporting, right? So we're going to have to somehow move in the direction of a carbon model, right? So what this bill does is says that let's use a proxy price, right? We don't have a system right now, and it's not proposing any carbon tax or anything. It's saying, let's look at the market. Let's look at what the Canada and the European Union are doing, and let's use a proxy price. Eventually, we're going to have to go in this direction. Let's use that when we make a decision. If we are renovating a state building, if we're building a new facility, if we're buying vehicles for transportation, let's use that proxy price as we calculate how much it's going to cost to run this thing over the course of its lifetime, right? So if you're installing a new HVAC system, either in a renovated building or in a new building, right? We price these things. How much is it going to cost us to operate this thing over the lifetime of that system? This puts this proxy carbon price in the mix, right? So if we say at this point in time, we have system A, a traditional kind of heating system, how much is it going to cost to operate that thing for 30 years, right? If in 30 years or well before that we have an actual carbon price, we have to factor that in. It's going to be part of the cost of operating that system, right?
Let's not use eventually we're going to have that. Basically what we're doing, we're just sort of having, I view this as sort of like a trial run. Mm-hmm. It's an experiment to see how this would affect our decision making. Mm-hmm. Is that right?
Yes. So thank you very much for asking that question. So the bill as it's written would require the Department of Administrative Services to factor it in. What I have thought about, and I'd be willing to, I'd be happy to talk to you all about, is the idea that through an amendment, we could change the bill exactly as you suggest, to say that it is not a binding part of the formula, but that when we make these decisions, they're calculated and they're recorded. And then over 5 years, over 10 years from now, or after the enactment of the legislation, we can look at that history and we can say, okay, what was the better decision? And if it turns out that this model would not have saved taxpayers money, then we have the evidence we need, right? And if somebody comes forward with a similar bill, you say no, because we have this evidence that it doesn't work, right? So I appreciate that. And I'm absolutely amenable, so to speak, to an amendment that would make it non-binding and simply have it be reported as a part of the process.
Okay, so I think that's helpful. The other issue is how much of an effort does it take for the fact that the DRA, the Department of DAS, DRA, the DAS is not here to testify against it, leads me to believe that they have no opinion of it, because they certainly are here when they're against something. So how how much of an effort is involved? It's not for every single thing that we buy. It's only for things that are related to energy. Is that right?
Yes, thank you very much, and I appreciate you pointing out that, you know, if the Department of Administrative Services, I assume, if this was a mountain to lift, they would come and they would say, you know, we can't do this. The effective date is January 1st, right, of 2025. So again, if this was a concern that they had that they couldn't do it in time, I assume that somebody from that department would be here telling us either, you know, we need longer or we can't do it. So I appreciate that question. And it is specific to purchases on equipment, including, say, automobiles that consume carbon, right? So it's not on everything. You know, when you're building a new structure, for example, it is specific, for example, to an HVAC system, as opposed to, you know, all of the other bidding that has to be done on the various kind of subcontracts. So yes, it is specific to those things which use carbon.
Thank you. My concern is what I'll term as a creeping elegance in the direction of electrification. We have seen hard evidence that across the state, at different points, there have been efforts to, and that we're talking at the consumer level. And I know this bill is right now not trying to attack consumer issues, but to me it's incremental. This is incremental efforts to get there at some point. That through the planning board process, there have been efforts across in different parts of the state, and we've seen evidence mostly along the western part of the state, close to the Vermont border, where planning boards have been encouraged or told not to approve any plans that didn't require electrification of utilities. You can't, you know, new homes that are about to be approved can't be approved with furnaces that use oil or gas. They have to use heat pumps, electric heat pumps, and so we've had to step in and say no. The consumer needs to be able to be in charge of making their own decisions about things like that, and the government shouldn't be mandating that. So my concern is that while that specific example doesn't apply really to this bill, it's this incrementalism or looking to push in that direction so that at some point in time you say, well, it's now time to flip the switch, no pun intended, but flip the switch to say we're going to now require what we were just before watching or looking at or evaluating. Now it's a requirement to say you must now, when you buy a heating system for the state, the new parking garage across the street is going to have to use electric heat pumps. It will not be allowed to use propane heaters or natural gas heaters or whatever. And that's what I'm concerned about is how do we are there any ways to put safeguards in so that this doesn't all of a sudden be like a giant blob that devours us, and we turn around one day 5 years from now and say, how did we get here? And say, well, it's everything has to be electric. I mean, and using myself, and please allow me, I'm diverting a little bit here.
No,
but
go ahead.
a couple of days ago with this heavy snowstorm we had, we lost in Londonderry, where I'm from, we have terrible experience with Eversource. We lose power all the time. And I happen to live on a cul-de-sac, which means you're going to get the power last back. But we lose power all the time. So to mitigate that, because I did a lot of business travel. And when I was gone, I didn't want my wife out there trying to pour gasoline into a small generator, and she was too afraid anyway. She refused to do it. So
All by yourself?
right. So I went out and invested $20,000 into a propane generator, a whole house generator. So when the power goes out, it comes back on in about 10 seconds, and she's got power and she's not in the dark and in the cold. That's an option as a homeowner that I want. It's an option if I were to translate that as a community, a police station. I want a diesel generator running when the power goes out to power the police station, not just an electric line to the electric company that's gone out anyway because there's no power now, or the fire station. They also have diesel generators to fire up, and now it's a safety issue. So what I'm concerned about is this electrification, but it doesn't. I'm thinking about the consumer side of it. We're not in this bill talking consumer, but we are talking about large purchases of government agencies. And a police station is a government agency. It's the state
would
police.
apply, right?
But once we require it for the state police, how long will it be before it migrates to the community police, or to the community fire station? So I just think we talked slippery slope earlier.
Everybody knows how I feel about that word.
Right. So we won't go there. But anyway, I just think we have to be very careful. We don't tie ourselves into knots and end up like California is now with rolling blackouts and brownouts and so forth, because they're so overcommitted to electrification. And even in large power systems like community power systems and so forth. So we've got, I would think we need some protection. And I don't know if it's a study or to do some analysis or, I'm not a big fan of studies because I'm on the commission to get rid of all these studies commissions that we have. But anyway, this to me, if you want to go down this path, it needs a lot more thought and a lot more analysis, so we don't back ourselves into the corner where we're now stuck and can't use our resources, our energy resources, to help us navigate through emergency periods and so forth.
So So I wanted to make sure that with the amendment that Representative Germana is proposing, what we would do is exactly, I think, what you're trying to do is we're only gathering data on the state level to see if this at all even works. So we're not going to make any decisions based on it, or we're not going to we're not going to decide anything on it. It's really just a matter of gathering data to see if this is something that would be beneficial long term, and maybe it won't be. But rather than mandating that we do something that we don't know anything about, what we're doing is we're in a way creating an experiment, which I'm a big experiment person myself. So let's experiment, let's gather the data, and then determine where we are. I would just like to know, for example, if we were doing this as an experiment, how much time do we need to gather enough data to know what the effect of this would be?
Thank you. And I'd also like, if I may, to address another part of Representative Dolan's concerns in terms of kind of what is the kind of safety involved here, right? So that we don't go down the slippery slope. And I would say that in this bill, the difference between what you see in California, for example, or some of the things that I think that you're concerned about, is that the specific target underlying legislation like that is the reduction in greenhouse gases. The target in this bill is what is going to save taxpayers money, right? So the fundamental underlying principle is not we're going to purchase the things that will have the least carbon footprint. I think that's the kind of thing that you're concerned about. And we could disagree about that, but this bill doesn't do that. This bill says that the metric that we're concerned with is saving taxpayer money. And I think if that's the metric, if that's the fundamental underlying principle, I think that should address some of the concerns that you have. Because as you said, it's not we're going to buy this thing just because it has a smaller footprint, right? We're going to do it ideally because it's going to cost taxpayers less. So I hope that speaks to some of your concerns about how this legislation fits into the larger patterns that you're concerned about.
I like the language about saving taxpayer money, but I think the evidence before us is that this is going to cost the taxpayers more money, and you have to look at long-term versus short-term. In the short term, if we could get $1.85 fuel, that would be saving us money as opposed to $5 a gallon. But $5 a gallon may be what the long-term cost is in terms of, the carbon footprint type analysis. So we really need to bring into the discussion short-term costs, long-term costs. Short-term costs, I think by maximizing energy availability is the tax saving formula in the short term. I think a case can be made that if we don't pay attention to the environment, that there's going to be a long-term cost that is going to cost us more in the long term. But that needs to enter into the discussion so people understand that we're going to walk away from $1.85 fuel costs, and we're going to go to a $5 fuel cost because 10 years from now, we're all going to be paying $20.
I hear what you're saying, Representative, but that's not, to my understanding, that's not how the Department of Administrative Services determines how they're going to purchase equipment, and that's what this is about. So I hear what you're saying, and that this became part of that larger discussion in the committee,
Right.
and that's an important discussion to have, and it's very complex for all the reasons that you indicate. That's not what this is about. And the Department of Administrative Service, as I said, to my understanding, does not use any of those things when it determines what kinds of equipment to
So
buy.
the question is, how do we do a test or an analysis that's not open-ended?
And I think that Representative Grota, Madam Chair, referred to that. So two things I would say. One, I'm happy to, I've asked OLS for some language. They haven't been able to get back to me that I would share with you all that, again, would make it non-binding. So in that case, we're gathering data. And then, if we want to talk about what kind of time period we're looking at, I mean, to say that it's open-ended, I don't necessarily think is a bad thing because it would require further legislation to change it into something that was generally binding, right? So if there's no further legislation and we're just gathering data for 5 or 10 years, whatever, we have 5 or 10 years worth of data to look back at. And again, if someone comes before the committee with a bill that wants to make it binding, we then can say, well, we now have, say, a decade's worth of data. So I personally don't see any need to put into the legislation a sunset date for this because it's not going to enact anything. It's not going to make it binding after a certain period of time. So I don't personally see that as being necessary, but
We typically don't keep things running forever. We
Okay.
typically have a sunset time.
okay. And so whatever the committee thinks is reasonable, I would certainly be happy to have that as part of an amendment.
Oh, I'm sorry, I didn't mean to step on you.
It's okay. I guess I need this. I've lived in a house with heat pumps, and they're fine, but they use electricity, and electricity is going to put whatever in the air. Plus, the cost of electricity is going to go up. So we're not gaining anything by using something like a heat pump. We're going to still end up. Something's got to, I mean, granted, maybe they'll put solar panels or they'll have wind or something to generate the electricity. But until we get to that point, we're a long way from it. Those aren't practical
Mhm.
just
Well-
for pollution purposes.
Well, what I would say, I appreciate that, and that came up in the committee hearing too, in terms of a lot of the things we power through electricity, right? 50%, I believe, of our electricity is generated on fossil fuels, and that would be calculated into the price. So again, in this case, if we were talking about a non-binding price, we're just trying to gather data that we can use over time. If the state is looking at different ways to heat a building and they looked at a heat pump, they would have to look at the carbon price attached to electrification. And then you would just look at, again, what is the cost efficient decision.
Yeah. Yeah, I don't know, maybe insulating the house more would help or something on that order. New windows so your air doesn't come in, but whatever. Heat pump is perfectly fine. It has good heat, no problem. I don't know that Jackie agrees with that statement, but
No, I do. It's just that I feel like we're talking about, we're not talking about existing things, because we're talking about things that the state would purchase that require energy. And they can purchase whatever they want. All we're doing is going to be creating a database that says,
yes.
If this had been considered, this would be the cost. And maybe we're going to find out that system, let's just take, for example, you buy a car that runs on gasoline, they buy a car that runs on diesel, and then in the non-mandated column, they have a car that's a hybrid. Let's just use those examples, okay? So, how much does the car that runs on gas cost? How much does the car that runs on diesel cost? How much does the hybrid cost? Right? Now, long term, if you were to look at the price of gas is the same, or the price of diesel, they have to look at which car was the most effective purchase at the time. All right?
Yeah.
So basically nobody mandated the town to buy the diesel car. But had they bought the car, would that number be lower long term than the diesel car or the gas car? And that could be, you can substitute a gas car, diesel car, hybrid car, for whatever. It could be a heat vac system, one with heat pumps, one without heat pumps, and one with, I have no idea what
Coal.
So, or I'm trying to think of something else that runs on
There's heating systems that run they run pipes under the ground. And
radiate. Yeah. So
radiation.
it's
no,
that kind of
not
analysis.
radiation. It's I'm sure you know what it's called. Where
Radiant heat.
no, it's you send the
Thermo. When they run something down to the ground.
yeah, they run it. Geothermal.
Geothermal.
Yeah, that's another one.
Right. So it's that kind of thing, and basically what we're saying is, in the decisions that the state makes when they're buying something, we want them to run this experiment based on what an alternative. It could be that they decide to buy the hybrid car, the gas car, and they put the diesel car in it doesn't matter what they put in there, right?
No, that's right.
I mean, it's how they design the experiment that we're not going to tell them how to do that.
No.
All we want them to do is
Is do
consider this experiment so that they can collect data long term.
Well, isn't the purpose of it to try to figure out what the carbon footprint is
No.
Afterwards?
No.
No, and that's why I was saying I hope that would address some of your concerns, because the bottom line is cost. Cost is the driver here. So another
Aren't you
example.
trying to convert carbon footprint into cost?
And I like the idea of Madam Chair's example, because our argument, our bet, if you will, is that over the long term, reducing our carbon footprint is going to save money. Right?
Yeah,
Now that's debatable, but that's not what this bill does, right? So that we would, especially if we amend it so that it is gathering data. So again, 10 years from now, you and I can sit here And we could look at that 10 years worth of data, and one of us could say to the other one, see, I was right.
All right, so what's the calendar look like?
How long are we gonna run the experiment?
Yeah.
Well, I don't think we should run it for less than 5 years, because I don't think that we're gonna gather any data that's meaningful. Because first of all, how many things does the state buy, number one? Number two, how long do these things last? You know, if it's a vehicle, they last for a long time, but the first 5 years of a vehicle, they're pretty efficient, and they're not falling apart. So I think 5 years is a good number. I mean, that's what
What
I'm
would the
thinking.
legislation look like, though, for a 5-year
They're
experiment?
gonna put it in, he's gonna put it in an amendment, and we're gonna look at it.
And it would be,
So
so
it
it would be,
would
there
be
would be a
study-
sunset
It would
clause.
be a study for 5 years, I think?
Well, I think what we would do, because we can't bind a future legislature, right? So we would sunset it, and then in that last year, if somebody wanted it to continue, then they probably would submit a bill, maybe me, for a study committee base, and then you could use data that you would gather as the foundation of as a study committee. But what I'm suggesting, as the Madam Chair pointed out, is that we can put a sunset clause in, and then we have this as something that the state calculates, but does not use as a part of its decision
And
making.
what
So the
agency would do this, do you think?
Department of Administrative Services.
Charlie Arlington.
And I think the other point is, and I like Madam Chair's example. The other one I was thinking of is if you were to buy an HVAC system or a car, either way, right? If you were to kind of do your own experiment and say, okay, well, I'm trying to decide between these two, right? Well, you have to choose one. Let's say you choose one, but you also kind of keep the records. Well, what if I had bought that other heating system, right? And then you can compare 5, 10 years out, 5 years out in this case, right? You can look back and either feel really good because you made the right decision, or feel bad because you think, man, I'm losing money. But so it would be like that, right? We're making a purchasing decision using the same metrics we currently use, and keeping the carbon proxy price as a data point that just for informational purposes, so that, as you said, down the line, perhaps there's a study committee that then can do what the original bill here intended to do, but we would have data to base that on.
Now, would we think that eDNA would be the monitoring?
Coming? Well, I think members, they'd have to, well, we wouldn't have a study committee. What we would have to do is after the 2-year period, if we renewed it, DAS, I'll speak to, we wouldn't be, this would be something that the DAS could report to our committee after they've collected the data. Yes, they would report it to us, because then we could say, we put together the study committee, because the reason why this bill is before us and not before Science, Technology, and Energy is because it involves the DAS, right? And because it involves DAS, they would be the ones who could come to us and say, we did the study committee and this is what we found, right?
Yeah, I would be in favor of keeping it in eDNA.
Yeah, okay. Okay, good.
And-
Yes, so that we don't lose track of it.
Right.
Right, okay, I think that's good, especially since this is yeah. Okay. So I don't think that, do we agree that we want Representative Germain to go to OLS and draft this amendment? And then do we want to look at it and meet again, or?
Yes.
Okay,
Yes.
so we're gonna do that. We have a meeting next week. So maybe,
We're meeting Friday morning, but that's probably too early,
That's a
right?
different,
that's the, that's
different
a
subcommittee.
different,
That's on,
is it possible to meet, can you have it, see if you can get the amendment by Wednesday by try to get it to us by Thursday, right? So we have a house session on Thursday.
Right.
And then we have an executive session that afternoon. So we could meet before the executive session, and let's try to do that. How's that?
I won't be here Thursday afternoon.
You won't? Bummer. Okay.
Nick, you're gonna go get the amendment?
Yes, and I'll have to ask them to add a 5-year sunset date. That wasn't part of the original request, so I'll, yeah, that's the easy part.
And that the report, DES has to provide the report to us, to our committee.
Yeah, that attendance could be a problem because I would be missing and you'd be adding and someone new, Matthew would be added and he would have the benefit of this discussion.
No, I know. Okay, so let me,
But I can meet Friday.
okay, well, Friday, I'm in Friday, okay, so I think here.
And I did also, based on Chairwoman McGuire's suggestion, I asked OLS to tell me what kind of rule writing empowerment language is required. I'm not, my understanding was that if we instructed the department to do this, that they would then therefore simply have to write the rules about how they do it. The chairwoman said that she believed that rule writing empowerment was required. I have asked OLS to tell me if that has to be a part of the bill, and if it does, that will also be part of the amendment.
Okay, so let's do this. I don't think that this is an early bill, but that's okay. So how about next week, we're meeting again. So let's make a,
We have exec session at 10 o'clock on Wednesday.
on the 7th?
Yeah.
Okay, so let's meet on the 6th at 3 o'clock or after our committee, okay?
Okay.
Tuesday, the 6th at 3 o'clock. We'll meet again and you'll bring the amendment.
6.
And this is House Bill 1486.
86.
1486.
3 o'clock, you said, Madam Chair?
Yep. And I don't know where it's gonna be, because it could be here again. We won't have our regular, I almost said classroom. Our regular, we won't have our, regular committee room. So we might be here, I don't know, but look forward in the calendar. Okay?
And we do have a committee
Hearing.
meeting on Wednesday, the 7th.
We also have one on the 6th.
Oh, we do?
Yeah.
Oh, I didn't
we
add
have-
my calendar yet.
Yeah, we have a hearing on the 6th. So, okay, this was very helpful.
Yes, it was.
Yes, thank you so much.
Well, I appreciate you all taking the time at the end of a long day to meet with me to talk about the bill.
Well, that's what we do, right? We all do that for each other. Okay,
Yeah.
I'm just looking at the calendar just to make sure that I'm not, Tuesday. We don't have a committee hearing on that.
have committee tomorrow?
Not tomorrow.
have bills tomorrow?
Yes,
Yes.
I'm talking about next Tuesday. Okay, for some reason,
I didn't have anything on next Tuesday, but
and we don't, it's not in the calendar for next week either.
we do have one for Wednesday,
No, we
the
don't.
7th.
It's not in the calendar. So let me talk to Carol, because we should be here next Tuesday. You know what, let's just, everybody, I'll schedule something for either next Tuesday or Wednesday, depending on what day we're here, okay?
Okay. Yeah.
That sounds good.
Okay, great. Thanks so much, and subcommittee meeting is over. We can.
Thank you for coming to the.
Yes.